Call this meeting of the Sunshine Ordinance Task Force to order at 4:08, according to the clock on the wall. Please call the roll.
On the call, the roll. Member Highland. Present. Highland present. Member Hinsey. Present. Hinsey present. Oh, sorry. Member LaHood.
Present.
LaHood present. Member Tesfa. Absent. Member Josh Wolf. Absent.
He may be late.
Yes. Member Martin.
Present.
Martin present. Member Yankee.
Present.
Present. Yankee present. Chair Wolf.
Present.
Wolf present. We have a quorum.
Okay. Any changes, adjustments to the agenda?
There are no agenda changes that I know of at this time.
Members? The only thing I'm under my chair's report, I'm just going to have some late-breaking case law that was transmitted to us by our legal counsel, just to announce that, and if anybody has any questions around it, it's timely, and we'll have a discussion at that time about it.
Ready?
Is there any public comment on the agenda?
That's public comments listed for 5 o'clock.
Oh, okay.
Actually, it doesn't list it, but we usually delay until 5 o'clock.
Okay. Well, I was just asking if there's any public comment on the agenda. If there isn't, then we will just forge ahead. I'm just getting my agenda out so I can read the decorum statement. Okay, any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and or menacing behavior may be asked to leave. Okay, let's call the next item.
Next on the agenda is item number 2, approval of minutes from the special meeting of the Sunshine Ordinance Task Force of January 21st, 2020.
Any changes or adjustments to the minutes?
Not on this, but just as comment that we don't have the January 14th minutes to approve from our special meeting, so we should probably put that on some future one.
Yeah.
But with that said, I would move to approve these minutes.
Okay. January 14th?
Yeah, our special meeting.
Oh, a special meeting.
Yeah.
Was it
I thought
21st?
that was the 21st.
The other special meeting.
No, the retreat.
Retreat.
Oh,
meeting.
the
Early, yeah.
Yeah.
Oh, did we not?
Yeah, they were not on.
They were not on that.
No,
on
it's just
that
December
21st
that we
meeting.
did last time, so we really should get those.
Oh, okay.
I won't so note.
But they were. Oh, yeah. Okay. Great. Okay. Let's call the next item.
Public comment?
Oh, I'm sorry. Public comment on the minutes?
Yes.
Go ahead.
Yeah, so this is very minor issue. So it's page 8 of the record, which is page 7 of the minutes. The motion for 19044, it says section 6721, like 6,721. There should just be a period between 6721B.
I'm sorry, that was on page 7 or page 8?
It's page 8 of the record, but page 7 of the minutes, where it says action section 6721B. Should be 67.21B, that's all.
Okay, got it. Got that, Victor?
Sorry, I was distracted.
Sure.
Could you restate?
On page 8 of our minutes, where it says action moved by member Yankee, second by member Martin, to find that city attorney's office violated
One
administrative.
moment, that's on page 9.
Sorry?
Okay,
It says section 60, it's supposed to be 67.21B.
B.
Yeah, not 6721, 6,721.
Oh, sorry, I must be, this is for item number,
This is for item number 8, file number
Okay, sorry.
19044.
on the wrong page.
Page 7. Well,
6721B.
Right. There any other public comment on the minutes? Seeing none, can we take it by acclamation with that correction? Seeing no objection, minutes are approved. Let's call the next item. Ready.
Next on the agenda is item number 4, file number 19108, complaint filed by anonymous against, actually, my apologies. It's item number 3. Next on the agenda is item number 3, file number 19091, complaint filed by anonymous against Mayor London Breed, the Office of the Mayor, Hank Heckel, Sean Osborne, Andreas Powers, Andreas Brush, Margarine Filnor, Jeff Cretin, Sophia Kittler for allegedly violating administrative code, Sunshine Ordinance Section 67.21, 67.26, 67.27, and 67.29-7 by failing to respond to a request for public records in a timely and/or complete manner.
Okay. This was heard on October 15th by the Complaint Committee for Jurisdiction Referred Matters to the Task Force. Is there anything to add, Chair Martin?
Not really. I mean, I think it's about 5 months ago. There was a metadata component that was taken out and put into information technology, I think, meeting. And this is just mainly about redactions, footnoting, and stuff
Okay.
being taken out.
Okay.
Put it in IT or?
Yes, we did.
Okay.
Okay. Everybody ready? Okay. Anonymous, are you ready?
Yes, I am.
Okay. Is the respondent present? Yes. Okay. Thank you. All right. Please reset the clock. Okay. You have 5 minutes.
All right. Anonymous here. Good evening, Chair and members of the task force. We're going to begin on page 31 of the record, which is page 24 of this PDF. On July 2nd of last year, I requested each respondent, there are 8 different respondents here, emails, chats, and text messages. I explicitly requested attachments. I also requested email headers, metadata, and native formats, but that is split to 2006, and I'm not going to discuss any of that. On a timely fashion, after an extension, on July 26th, 27th, and 29th, they did provide the records. They provided a generic list of 4 to 8 redaction reasons without a key between the hundreds of different redactions and those reasons. They provided some, but not all of the attachments to the emails, and they only cited attorney-client and attorney work product privileges to withhold entire records. So I filed this complaint, and I filed a supervisor of records petition. On September 5th, the supervisor of records neither granted nor denied my first petition, but stated that the mayor's office will provide the redaction reasons. The respondents failed to provide them. On October 10th, the supervisor of records denied my second petition on the same case, yet also stated simultaneously that they will indeed provide the non-exempt attachments. Respondents provided 1 attachment. The supervisor of records issued no orders. On January 15th, I filed a third supervisor of records petition due to the respondents' continued noncompliance. And on January 16th, they finally provided the key that they're legally required to provide for the redaction reasons. On January 17th, it turns out there are 26 additional email attachments that they had not provided before, even after they told the supervisor of records that they would. And they added one new full withholding reasons, and the supervisor records now claim that they have respondents have finished complying. On January 25th, I filed a fourth supervisor records petition because I can now actually dispute the individual redactions and withholdings. This saga continues. Next page, please. Now, even if you don't agree on any of the individual redactions I'm going to dispute in the next few pages, already at the state of this complaint, there are clear violations here. There's an incomplete response because they did not provide 26 attachments until 5.5 months later. Respondents did not provide a key by footnote or other clear reference to the justification until 5.5 months later. And respondents did not even deny this allegation in their response to my complaint. 6727, they did not actually cite the withholding reason of 6254C for personnel information until 5.5 months later. They had only cited the attorney-client and work product privileges. Now, I'm going to show you in the next pages, and you can ask me questions because there's quite a few disputed redactions. I believe they are still violating 6726 for non-minimal withholding. And if you go to the next page, I don't know why it's so extremely difficult to read this, but this is the fourth petition I've now filed to the supervisor of records. It goes through details of which redactions I am disputing, the legal reasons for disputing them, and other types of withholding that have nothing to do with email metadata that they continue to illegally do. I don't know how much time I have left. I can go through individual ones of these, or you can just ask me questions of them. They are withholding, images that they should provide the whole image. They can't just provide half the image because they decided to print it out. They're withholding various URLs of news articles. They have somebody in the mayor's office who sends like batches of news articles to the mayor, I guess, on stuff that's relevant to her. They withhold all those URLs. Now, we know they know how to provide simple PDFs because they did it in 1 out of the 11 record sets in this case. Why they didn't do it for the other 10, I have no idea. But there's also a lot of individual redactions I am arguing against. For example, Margin Silhauer, I apologize, I don't know how to pronounce their name, uses apparently their personal email to conduct public business. There's a law called Government Code 6254.3b1, which does not allow you to redact or withhold your personal email if you're going to use it for public business. And there's all sorts of examples. If any of part of this is unreadable, I am happy to read to you the original of this. I think you should clearly find a violation of 6721B, 6726, and 6727, even if you don't agree with me on any of the redactions I'm challenging. Thank you very much.
Thank you. Are there any persons or witnesses to provide any facts or evidence on behalf of the petitioner? Seeing none, respondent.
Good afternoon, members of the task force. Good to see you. I'm Hank Heckel. I'm the compliance officer in the Office of the Mayor, here to respond to Anonymous's complaint on behalf of the office and on behalf of the individually named respondents. Just preface this by saying we make every effort to fully comply with records requests in the Office of the Mayor. As the members all know, we've been working with Anonymous for probably over 6 months in responding to numerous requests from him and working through some issues. Anonymous's timeline is not really in dispute here. It pretty much tells the story. He sent a quite extensive and voluminous request characterized as an electronic communications audit to our office, naming 8 custodians across 17 categories of media, requesting the 10 most recent communication strings in each of those categories for each of those custodians. So I did the math. That's potentially 1,360 sets of records requested by his initial request. As he said, we timely responded in the appropriate time frame. We provided hundreds of pages of records in response. We've continued to work with Anonymous over the months in addressing some of the sort of housekeeping issues that he had pointed out, and we had an initial discussion of this at the complaint committee. We've divided out the metadata issues as was said, so I'm not here to address that. But there were some other things like the redaction keys, which we don't. After going back, we agreed that we needed to identify those specifically. So we provided recently, as he said, we provided the redaction justifications in the first instance, but just in sort of a batch format where I think in most cases it was apparent which redactions applied, which justifications applied to which redactions. But since then we went back and we keyed it up and identified, by line item what each the justification for each redaction. He also made some follow-up requests for things like attachments, so we provided all the missing attachments that he asked for. We provided 26 of those. The other things I think are really in the nature of foot faults and sort of minor things that we can work with him on. In terms of images, I could sort of dispute all of his redaction, the justification disputes that he has for some of the redactions. With respect to the personal email issue, there were some documents where Marjan Philauer, I think the point here is that she had been emailed from someone outside the city who probably had her personal email address for whatever reason and sort of initiated a city-related discussion with Marjan. So it was it's not that she uses her personal email address for city business as a matter of practice. So we believe the withholding of her personal email address is justified under the balancing test associated with the California Constitution and other protections of personal privacy, and we believe that's appropriate. We believe the other redactions are justified as well, and we can sort of go through them line by line. But if there's any leftover items where we remain open to supplementing our production as is feasible and appropriate. Thank you.
I'll note for the record the respondent has stepped away from the podium. Are there any persons or witnesses providing any facts or evidence on behalf of the respondent? Seeing none, I'd also like to recognize Vice Chair Wolf, arrived at 4:16. Okay, members. Questions, clarifications?
Got a question for Mr. Henkel?
Member Highland.
Hi, yes.
Hi. As you heard, we got walked through a pretty complete timeline. Would you have anything to add to that, or are you in agreement with the dates and the materials provided according to this timeline in the package? Page 31.
Right. Yeah, I mean, I think we don't have a dispute with the sort of rough timeline presented here. I mean, I think there were additional communications that sort of, could be added to that, including the discussion of these issues at the initial complaint committee. But, I mean, we've been in constant contact with Anonymous on this, and, we probably have hundreds of emails from Anonymous that are either requests or follow-up to requests, and so we're sort of in regular contact and dialogue with him.
Thank you.
Mr. Henkel, I have a question. Are you disputing timeliness?
As to what?
Well, I mean, the timeline is clear that from the time that the request was made to the time that documents were provided was like 5 months later.
We provided all the documents in a timely fashion. We provided the vast bulk of the documents in a timely fashion. I think Anonymous said that we took an extension. We took a timely extension. We responded substantively in a timely manner with the bulk of the documents, and then there were some supplements in terms of some missing attachments. As I pointed out, you're right. That was in January, and there was also the redaction. We provided the initial redactions originally, and then we provided the specific key also in January.
That's not clear to me. So, are you saying that you are agreeing that there's a timeliness issue here, that you were not within the time frame allotted for responding to these documents, to the request?
No, I mean, to the extent there's a timeliness issue, I mean, we believe that our substantive response was timely. I mean, there may,
but it's, I mean, according to the timeline here, it says the response was due after an extension that you invoked on July 26th.
Right, and then we provided hundreds of documents within the extension period. Then there was some back and forth because this was, as I said, something that called for over 1,300 categories of documents. Compliance may not be perfect in terms of we could foresee sort of every, attachment, or there were things that were inadvertently not provided along the way. And so we worked to, through this process and in consultation with the city attorney, to sort of clean that up and provide the attachments, for example, and to provide the redaction key. So my contention is that the bulk of the production was provided on a timely basis. The rest is in the nature of supplementing in response to specific things that he said were missing.
Okay, thank you. Anonymous, is your complaint now solely on timeliness?
No, it's on page 32. The timeliness is just, and I agree with him. They provided about, I think it's like 300 pages on a timely manner. I think it was, I don't remember, on a timely fashion on a rolling fashion from July 26th to 29th. The only thing that was untimely was 26 attachments. I emphasize that not because because they were told by the
Hello?
The record parts are the redactions were not key, the 26 answer, and the fact that they lacked a justification in 27.
Okay, so we're to focus on just the 26 requested attachments?
I'm really not understanding your question. I apologize.
Well,
are you asking what do I think is still outstanding now, or are you asking what did they violate when they gave me the response, whenever they gave me the response originally? Which are you asking? I apologize.
Well, I mean, this is a little complicated because there's so much information here.
Yeah.
So, and I'm looking at your notes, and we're talking about what I'm seeing here, like on January 17th, response provided 26 new attachments, and then that's on page 31 of our agenda, and then on page 32 you notate a violation of the 26 requested attachments didn't arrive until 5.5 months later. So is that what we're focusing on here?
No, that's just one of the three violations. All the other redaction issues were on the bodies of those emails that they gave right at the beginning in July 26th.
I get that, but I'm just talking about the outstanding records to start.
No, the outstanding records, I don't believe there are any outstanding entire records. It's just we're disputing individual withholdings in the records they've already provided.
Okay, so we're not discussing the according to your list of suggested violations, incomplete and untimely response lacking approximately 26 requested attachments until 5.5 months later under the 6721B. That first one on page 32. Is that?
Yes.
Are you still holding that as part of your complaint here, or are we just moving into the redactions?
Yes, I'm asking you to find that violation. I don't think they dispute it. I don't think they do. So.
Okay, that's what I'm trying to confirm, Mr. Heckel. Are we in agreement here that these approximately 26 requested attachments didn't arrive until 5.5 months later?
Yeah, I'm not disputing that.
Okay.
I mean, it was follow up to his request for missing attachments. So they weren't. So to the extent they weren't provided, it was inadvertent in the first instance.
Okay. All right. So members, note that for the record.
Chairman.
Yeah. Go ahead.
I think he references several other code, sections 21, 26, 67, 27, 16, 21, 7 as part of his complaint, 4 different areas of suggested violations.
Yeah. No, I see that. I'm waiting to hear if somebody else has anything
Mr.
else.
Heckel,
Member
can you
Martin.
come back. Thank you. So I'm on page 32 of what was referenced, and there's a summary of kind of what Anonymous thinks is at issue here. 67.26, were the redactions not keyed to, the footnote or whatever? Is that also the case?
Yeah, right. So in the first instance, we provided documents that some of which had redactions, and we identified bases for those redactions, but they weren't in like an index or key format.
Okay.
We provided that later in January. I mean, I would submit that the 67.26 doesn't explicitly have a timeliness provision within itself, so I don't think the fact that they were provided, I would say we've complied.
Yeah, you worked that out.
That's separate and apart from the 67.21B issue.
So 67.26, they weren't originally keyed, but since then it's been.
Yes, we provided the index, and I don't think Anonymous disputes the format or the sort of clarity of the index.
And your response to 67.27 alleged violation, I would imagine that we did provide something. If it didn't end up being on point, then.
For 67.27?
Correct.
Honestly, I'm a little unclear as to what Anonymous's basis is for this violation. I'm not sure if he's disputing. I mean, he mentioned some of the justifications for redaction. I'm not sure specifically if that's what he's pointing to 67.27 for. I mean,
I don't want to speak for Anonymous here, but I think he might be alluding to that. Listen, you cited 2 things that didn't apply, and then you went back and said, "Oh no, actually, it's this." I think that's what he's saying. Anonymous, are you there?
Yeah, I mean, I think we did.
I am.
I think we did provide the exemption. There were records that related to some hiring issues, and so those were redacted in the first instance, and we invoked a personnel exemption. I mean, if you want, I can sort of address the specificity of what Anonymous is disputing.
I think you said they were initially cited, though, as attorney-client and work product and not personnel.
That may be what he's saying. I'm actually not. I apologize. I'm not fully. I don't fully understand his argument on that basis, I guess.
Well, I don't know. Yeah, I think it's an observation. Do you think that matters if they were labeled incorrectly? I guess is the question I'm asking you. The purpose of the redaction.
I mean, I don't know that they were. I mean, if they were, there might have been like a typo or something. But I'm pretty sure the range of bases of justifications was provided initially, and then the key was provided later.
Okay, thank you. Yeah. Anonymous, can you weigh in on that?
Yes, I can. That's not what's going on here. So redactions are under 6726. 6727 is for the whole record, and I'm finding the page number so I can show you exactly what happened. Let's see. I'm scrolling through here. So basically, the first time they responded, they told me, not redaction, but for withholding entire records, that it was attorney-client and work product privilege. And then when they came back in January, they added the reason of withholding certain entire documents on the basis of hiring reasons. And I hope Mr. Heckel remembers this, right? So they gave me 26 additional attachments. They withheld another 2 attachments on the basis, entirely on the basis of this hiring exemption. That's what I'm saying.
Okay, so the second round, they said, listen, we're still holding these 2 because of the hiring exemption.
Yeah, and they had decided that, yeah.
Right, but now they do, and they're still withholding them?
Yeah, and I'm not disputing that
Okay.
withholding is wrong. I'm disputing the fact that they didn't tell me that at the beginning.
Okay.
Yeah.
Okay, thank you. So, I mean, it looks like there's a timeliness violation with the 26 requested attachments. There may be a issue with the redactions being keyed to an index.
Let's hold the summation until after after rebuttals.
Okay.
We just want to collect information here, get any clarifications, so that we have everybody is clear and on the same page. Anybody else? Anonymous, for the second violation, are you declaring timeliness in that one also?
It's not timeliness. It's 6726 says they have to do this as part of the exemption review, and I think you guys have discussed this before. But they can't they have to do it, and they have to give it to you when they give you their response. They can't just give it to you because you file complaints. Yeah.
I get that part. But besides that, because you notated that they weren't keyed until 5.5 months later, that's that's a timeliness issue. Whether it's a violation or not is something that we'll discuss. But are you claiming a timeliness issue in addition to it not being the justifications not being provided at the time that the redactions were delivered to you?
Yes. I think I understand your question now. Yes, I am.
Okay, thank you. And are you claiming that for the third violation under 6727, are you saying that they gave you one reason at the beginning and then gave you another reason at the end?
Correct. They gave me 2 reasons in July, and now they're up to 3 reasons 5.5 months later. Yep.
Okay, thank you. Mr. Heckel, I have a question on that last one. So, what was can you explain how that went down? I mean, at first, there was initially cited that it was for attorney-client and work product privilege, but then later it became a different reason?
I don't think it became different. I think there might have been an added justification, but I mean, you don't need more than one, right? So it's sort of, I mean, we may have added it for completeness, but I think it's within our right to, if it's exempt as privileged, it's exempt. It could be exempt for 3 other reasons, but that doesn't, it can't be extra exempt. It's either disclosable or exempt.
I guess what I'm getting at is a catch-all. Like, we're claiming everything to be under attorney-client or work product privilege, but then for some reason, a half a year later, it becomes some other reason, and now you're going to release records. So I'm just wondering if it was, I'm not saying there was anything nefarious, but maybe out of convenience, it was used in that way.
No, I mean, I think if anything, it was probably just added for sake of completeness. I don't think it needed to be added.
What if 5.5 months prior it was cited, we're not going to release these documents or these records under the hiring exemption. I'm sorry, under attorney-client privilege or work product privilege. So you withhold the entire package. What changed? Whoever made the decision, what changed their mind to then come out with a hiring exception 6 months later, almost 6 months later?
Again, I think it was just going back and looking at it again. And like I said, it's not changing the initial exemption. It's just adding an additional one. I mean, I don't even think, we could withdraw it probably. I mean, it's just sort of, I think it's just an added belt and suspenders sort of thing, but it doesn't change the disclosability of the record.
So there were what, 28 requested attachments, and you held back 2 attachments? I mean, I'm not following how this is working. In the beginning, when you cited attorney-client or work product privilege, it was for the full record withholding, and that was for all the documents, correct?
For all the attachments?
For all the attachments?
No.
Anonymous?
No, the attachments are, like as Anonymous said, we just provided them after his request for supplementation, and they may have been inadvertently withheld. It's not that we never had attachments that we withheld and then later decided, we don't have to withhold these anymore. We went back and provided attachments that were missing, and then I think in doing the index of redactions for one document that was an attachment, we added a citation, I think, to a personnel exemption in addition to attorney-client related exemptions that had already been asserted with respect to that overall communication.
Okay, so I'm just somebody's going to have to clear up. I'm confused as to when these 2 attachments arrived. Did they arrive at the beginning or did they arrive at the end, at 5.5 months later?
What do you? They weren't produced, so I don't know what you mean by arrive.
They weren't produced at all,
and they still haven't been produced because of the exemption.
Okay, and so you just supplemented your initial citation of attorney-client and work product privilege. 5.5 months later, you added on to that by saying that we're not releasing these 2 attachments based on a hiring exemption?
Right, as in the process of doing the index in which, it was sort of laying it out clearly, lining up each redaction with each exemption.
Okay, thank you. Anonymous, can you confirm or deny that?
I agree with that. I will agree with what Mr. Heckel just stated, yes.
Okay, and so then with regards to that, what under 6727 are you expecting as a violation? As far as a complaint.
So I believe the 6727 states that all withholding must be justified in writing. I think what they're arguing here is they weren't withheld, they just didn't find them. So I guess if you want to do it that way, then it's just then you would be just 6721B. If they had found them and they didn't give them to me, I can't tell you which one it is, then it's 6727.
But if they, under 6727, didn't they give that reason in writing, that it was for under attorney-client and work product privilege at the time?
Correct. They originally gave me attorney-client and work product privilege, and it turned out there was a third justification later on.
Okay, but they gave you a justification.
Oh, so no, hold on. Sorry, there is a mistake here. It's not that one record is under all three justifications. I see what the confusion is. It's not that those 2 attachments are being held under attorney-client privilege, work product privilege, and hiring exemption. It's that a different set of documents were withheld under the attorney-client and work product privilege, and then another set of documents were withheld under...
We can't hear you. Hello? Hello?
You can't hear me?
No, cannot hear you.
The hiring privilege, and that was cited later.
You're going to have to repeat from the point at the end of my question, when you were saying now you understood why there's confusion.
Can you hear me? Can you hear me?
Yes, we can hear you. Hello?
Yes, can you hear me? So, sorry, can you repeat the question that you'd like me to repeat again?
I'm saying we could not hear your response to my question after you had stated that you can see what the confusion is.
Okay, I'll state it again. So I can see what the confusion here is. It is not that the two attachments that they're still withholding are being withheld under 3 different justifications, and they just gave me an extra one. That's not what's happening here. Basically, a set of documents were withheld for attorney-client and work product privilege many months ago, and those are the 2 reasons they gave me. And then these 2 documents are being withheld under this 3rd new justification. I don't believe anyone is claiming that those 2 documents are privileged. So basically, it's either that they had found these documents and they didn't give them to me 5.5 months ago and they miscited the justification, that would be 6727, or they, that's what Mr. Heckel is saying, actually they just didn't perform the complete search, now they found those documents, and it's just a 6721B violation.
So are you saying that under hiring exemption GC 6254C that's they're incorrectly withholding those records? That provision doesn't provide privilege?
It's not privilege. There's just 3 different justifications. I'm not disputing that the current 2 attachments are withheld improperly this moment. I am not disputing that.
Okay, then I'm not following what your 6727 complaint is.
Okay.
Because I'm reading from your document, and if the 2 attachments are not applicable, or you're not disputing the 2 attachments with regards to 6727, I'm not understanding what's on the paper here.
Chair Wolf?
Yes.
Okay.
I think I understand.
Okay.
I believe that Anonymous is saying that initially reasons A and B were given, and then later on a reason C was given. And because reason C was not given in the batch of reasons with A and B, either the wrong reason was given initially, or the citation to hiring exemption reason for withholding applies to one of the documents that was not discovered until later.
Exactly.
Okay. Okay. I don't have any other questions with regards to this. Go ahead, Member Yankee.
Anonymous under 6726. Are you? I know you said you didn't get the justifications until 5.5 months later. Are you also disputing what those justifications are?
Absolutely. That's on page 33 and 34. There's, I think, 20 different redactions I am disputing.
That's, is there a way you could, for us, kind of summarize what those 33 or 34 are? It's kind of difficult to read, and that's a lot of bullet points here for us to go one by one. Like, are they main categories?
Sure. So certainly I can do that. So a bunch of them are emails that look like business emails. They are not personal emails. They're coming from various organizations or companies. I don't believe you can redact non-personal email addresses when they're emailing the mayor. A bunch of them are, I think it's the same Margin Philhauer, and I have in the record, and I can give you those page numbers, pages where that officer is sending emails from their personal account explicitly talking about public business, and I believe under Government Code 6254.3B1, that is explicitly a disclosable public information. And then, as Mr. Heckel said, there's just some what he calls housekeeping. It's basically like portions of records haven't been provided, presumably just because of the way they provide the records, where like images just get cut off because they print them on a piece of paper, or images aren't provided in color. I don't believe you can withhold that information. You can still give me PDF. I'm not looking for any metadata. I just need the full content of those items. And the last section is the one at the top here. There's a bunch of tables about homeless beds and shelters, and that's one of the most interesting ones. I don't believe that follows exactly in the two exemptions they have cited for that information.
Where's that? I'm confused where you're referring to for this table.
Sure. So we're on page 33 of the record. At the top bullet, where it says page 2, 3, 6, 7, and 8 of Andre Power's number 1, they cited as ongoing negotiations regarding real estate and draft recommendations of the author. See Administrative Code 6724A and C. If you scroll down, you can see those tables. I'll give you a page number here. So the tables about homeless shelters begin on page 65 of the record. It's strange because parts of the tables are removed. In order for them to properly back this information, it has to be the opinion of a official that they would normally discard, right? The draft exemption is much smaller in San Francisco. And I don't see how this portion of a table where they're counting up homeless shelters has anything to do with that.
Okay, so would it be fair to say that the two main categories of redactions that you're disputing are various emails and then that table that we just took a look at?
And the third is just not providing full contents of images and URLs. Yeah.
All right, thanks. I guess, Mr. Heckel, could you talk a little bit about why parts of this table were redacted?
Can you cite the page? Sorry.
Yeah, looks like it kind of starts on I'm looking at the numbers at the bottom, like page 66, 67. There's tables that it looks like they're included, but then portions of them are blacked out.
Yeah, so what these communications relate to internal discussions regarding siting, like real estate sites for potential shelter facilities, and this is, I think, is a running list. So some of these are produced. Those are the sort of publicly consummated shelter sites, and the rest reflect sites that were under consideration and therefore constitute a draft sort of recommended site, and also reflect the internal negotiating strategy of the city regarding a real estate contract negotiation, and therefore also subject to, it's actually 67.24E, I think. I think somebody said the C maybe because it's hard to read, but it's E.
Oh, E. Okay, so you're claiming that's under the contracts, bids, and proposals portion?
Yes.
Okay.
Mr. Heckel, so two things. One is, hold on. Let me ask the anonymous question first. So with regards to
Yes.
Marjan Filauer's email address, can you show what examples that you're citing to be in violation?
You completely cut out. Your mic cut out until the end of that question. I apologize. Please restate your question.
For the email address that you're concerned about under the name Marjan Filauer, where it's been a personal email has been redacted, can you point to the examples in your submission, your record submission here in the agenda?
Yes. So it is. Yes, it's page 57 of the record submission, where you will see that's page 57 of the record submission, which is page 50 of the PDF. Halfway down the page, you see an email sent by Marjan Silhauer on Monday, July 1st, 2019, where they asked a person in the public whether they have a preferred date for reception.
You cut out again. Hello?
Where is being invited.
All right, we didn't catch any of that. You cut out. We're having some communication issues here, and it's if it's going to continue, it's going to elongate this case.
Can you hear me right now? I'll try to be very quick in what I say.
I can. So you said at page 57?
Correct.
Okay. So I'm looking at page 57. I see Monday, July 1st at 1:31 p.m. Is that what you're referring to?
Yep. It says Phil Howard Marjan wrote, and the email address they used to write that has been redacted. They sent that email about public business.
That's not on my page 57.
Oh. So, okay, this is very strange. I know that Ms. Leger had to republish the PDF, and the page numbers may be different. Maybe that's why we're so confused when we're discussing it. So for me, that's page 50 of the PDF of item 3 and page 57 of the bottom. It seems like that's not matching up with what you guys are seeing.
Right, it's not.
Yeah, it does.
It is?
In the middle.
But does it say she wrote?
So it's cast for Chair Wolf, and I think you guys are not seeing the cast version. I think that's what's happening.
So it's 57 on the actual page, not on the scroll.
Right.
No, I'm looking at what's printed
Right.
on the page.
So 57 on the page, if you start from the top of the page, there's a black box on the left and one sort of in the middle of the page. That one shows that Marjan Phil Howard.
Yeah, but I'm listening to what Anonymous says, and it says he's saying that Marjan Philauer wrote. Are you saying that is what's printed on the page?
Yes, after the box it says wrote. So the name
I
and then
see.
the email
Okay.
blocked out and then wrote.
Gotcha. Okay. Now I follow where you're at. Okay. All right. So Anonymous, that redaction are you relating that to Marjan Philauer?
Yes, I am challenging that under 6254.3B1. Correct.
Okay. So, Mr. Heckel, this is somewhat interesting because when you look at the formats of all the other emails, where it's formatted here, where it says Philauer, Marjan, open parenth, MYR in caps, close parenth. Usually the email is not, if you look in all the other emails, the email is actually not printed. Okay, so the question is what is that under the redaction?
So just to clarify what I think is going on with this document, and this kind of relates to the point I made earlier. So this whole discussion, if you look at the bottom of the page, was initiated by Alfonso Perez, who is a non-city person, community member. I believe this relates to the Filipino Heritage Parade, so that's a community stakeholder in that event, is emailing with members of the mayor's office regarding the mayor's participation in that event. He sends the email. I think it's important to note he includes Marjan's city email address, but for some reason he also includes her personal email address. And so he initiated a conversation with the personal email address, probably because he just had it in his contacts or something. And then so we're withholding that on the basis of personal privacy, and we don't believe that a city employee should forfeit the privacy around their personal email address because someone else initiates a discussion with them.
I guess with this particular example, when you look at it, if the message from Alfonso Perez came first on Wednesday, July 26th, and we look at the headers there and the information after the header, there we see the exposed email addresses from those particular persons. It's actually quite unusual. I've never seen it that way, actually. In some cases I have. But nonetheless, there are two references to Marjan Philauer, and they're both marked mayor, with a reference to mayor. Okay?
Right.
So and then in response, it looks like she responded from not the SF.gov email address, right? But this is in the course of doing official business.
Right. So, I mean, I'm not certain. It is odd that the second Marjan Philauer also has MYR in the as like a suffix to it. So I'm not. My understanding is that this was her personal address, and if that's the case, we're still contending that that is properly withheld for privacy reasons. And even if she responded again, I would just say that the conversation was initiated by the other party, including her personal address, perhaps in addition to her city address. So I would say that just sort of inadvertently, you get an email pops up on your phone and you respond to it without maybe realizing that it's your personal address. I would argue that doesn't forfeit your privacy rights under the California Constitution. But I'm happy to go and double check whether that was also her city address, because there is but I don't know how that would, why would that would be done, or whether the MYR suffix is somehow got associated with a personal address.
Okay, thank you. Anonymous, is this the only instance that this has happened in the documents that you received?
No, I don't. I think only this person seems to have used this. I don't think I have any other evidence of other people doing it.
No. But are there any other documents for this particular person?
Yeah, I think that same person in all sorts of different emails in this one thread. It's just basically the same email address, I assume, redacted in various places.
Yeah, I guess I'm trying to challenge whether it would just happened in this one instance of all the records that you got, or whether there's a pattern here. There's like it's happened in multiple different documents that you have received.
I do not have any evidence that this is a pattern that she uses. No, I don't have that evidence.
So on this page 57 is the only time that's happened that you for the purposes of this.
No, page 50.
Go on.
I apologize. Page 57 is the exhibit I included. I haven't gone through every document. I didn't. I thought I'd just have to show you examples of the redaction. I didn't go through all of them. But no.
Well, I mean, it comes if somebody made a mistake by sending out a message off of maybe the wrong account, the way it came up, a person can't be necessarily faulted for that. But if it seems like they're consistently using outside private communications, that would trigger something else. So that's why I asked.
I understand what you're asking. I have no evidence that she's doing this as a pattern.
Okay.
I cannot prove that to you.
Okay, thank you very much.
Can I respond to that, just to add one thing? So I think if you follow the string through the email, the chain continues. Mr. Perez sends an email on July 1st to Marjan's city address, which is provided. And then Michelle Marcayada, Marjan's assistant, replies and the chain goes to, like at the top of page 55, you'll see there's a chain with Marjan's city address, and there's no use of a personal address there.
But well, there's no email addresses that are revealed anywhere there except for Mr. Perez's. And the same thing for the July 1st one, except for Mr. Perez's on page 56. It's the older one. It's Mr. Perez's first email on June 26th that reveals the email addresses.
Right.
Right?
Right.
And then on July 1st, Ms. or Mr. Phil Hour responds, and according to you, they were using their personal email address. And then if we float up to page 50, the middle of 56, on March 1st, we have Mr. Perez responding, and now all those email addresses have disappeared. Okay? They obviously could not have been redacted or whited out because of the spacing between the names and the semicolons, and the proximity to each other. And if we continue going up and we see an email from Michelle Morkaida, her email address is revealed. That's on July 1st. And then we go back to Mr. Perez, and again, when he responds, the emails are not revealed. So, that's really my question. I'm not seeing Marjan Philauer's email address being repeated twice the way it was in the very first one.
It is on page 56 on the
page
bottom.
56, it is twice there, which is interesting.
I think he might have initiated it with her city email address twice and then her personal address.
It's hard to tell.
I think that's what it was.
For me, this is a single instance. I don't see a running pattern of a city official using outside external communications to conduct the city's business. That's really what I was kind of getting at here, and I'm not going to pursue that.
Yeah, we agree with that. Thank you.
Okay. Anybody else are we ready for rebuttals? Okay. Mr. Heckel, you are first. Okay. Wait for the clock.
Thank you, members of the task force. We've kind of covered a lot of the ground, I think, in this complaint, which I think really comes down to just sort of following up and providing Anonymous with some items that he requested and making some clarifications. I would argue that the redaction key is something that he doesn't dispute. I think the clarity of the redaction key. I mean, our approach to this initially was that we believed that the redactions were kind of self-evident. To the extent there's like an email chain and someone saying, hey, we should look at person X for this position, and someone responds and says, okay, send me his resume or something like that, a personnel redaction is sort of in a list of, say, 3 redactions. It's clear that redaction applies to that document in a set of 3 documents, say. But anyway, the index was provided. I would also submit that 67.26 doesn't have a timeliness component. The justifications were specifically keyed. He's not disputing that. The vast majority of all records requested, over 1,300 categories of documents, 300 pages of records were provided in a timely manner. And to the extent there were attachments that were needed to be given later, that was inadvertent, and we went and we found them and we produced them. So I would argue there's no violation there. And as to the 67.27 issues, I think we never changed our basis. I think clarifying what was said earlier, I think there was always this personnel exemption out there. So when the attachments were were looked at again, it was clear that certain documents would be withheld under that basis, and that was provided. And I don't think there's any dispute that's been proven up as to the impropriety of any of the other redactions, nor do I think that there's any issue, as we discussed, with redaction of the personal email address. And again, I think that pretty much covers the waterfront, but happy to address any outstanding questions.
Thank you. I'll note for the record the respondent has stepped away from the podium. Please restart the clock for the petitioner's rebuttal.
May I begin?
Yes.
All right. So I think they said that, well, the redactions were self-evident. I can show you how they weren't at all. If you go to page 18 of the PDF, I don't know why it doesn't have a footer number. You'll see a table. On the left-hand side is the generic redaction reasons they gave in July, and on the right-hand side is the actual key, and you can see on Power 1. There is no way for me to know which tables are attorney-client privilege, which tables they claim are draft, which tables they claim are negotiations. I don't think that's on me to figure out. And I'm just going to read to you what the city attorney used to advise in the Good Government Guide for some reason until March 2018, when this sentence was removed. Quote, the department must redact the exempted material and annotate the redacted text by referring to the provision or provisions of law authorizing the refusal to disclose, Admin Code 6726. And for some reason, they removed that from the Good Government Guide in March 2018. But that's exactly what 6726 requires. I can actually agree with you that if they've never used this email address before, then you don't really need to find that violation. So I think at this point, all that I need to receive is the images and URLs that I have cited. There's like a list of news articles. I don't think Mr. Heckel is opposed to providing me that information. There's no reason not to provide me that information. And you should find a 6721B violation for not providing those attachments until 5.5 months later. I believe that the text of 6726 does require them to provide that key. I believe they're supposed to do that as part of the exemption review, because otherwise it allows them to get sloppy in how they redact, right? If they don't have to be held to particular justifications, it kind of allows them to redact whatever they want. And even they were told to give it in in September, and they still waited until January, which frankly I have no idea why. That's it. Thank you very much.
So I have a follow-up clarification question, Anonymous. On this table that doesn't have any page numbers on it, did you create that, or did they create that?
I made the table. The left is their original emails. The right was then they went through and gave me those in January.
So is this what starts out with Exhibit A? Is that the table we're referring to here?
Yes, there's many Exhibit A's, but yes. The left side is what they gave me originally, and the right side is what they told me in January.
Well, where's their original document? Did you provide that? Or
not enter. I mean, I've entered their responses into the record, but for whatever reason, they never added all the stuff that they're saying is mitigating this into the record. I'm not sure why they did that.
Because it's hard for us to follow without seeing it on the original record. You know, what is what? Where you've parsed it out in your own table. It makes it hard. It makes it hard for us to.
That's exactly. I'm sorry.
Go ahead. Go ahead.
So they have not done. They did not provide it on the actual record. They've never done that. They instead just give me the narrative that table.
All right. I'll Mr. Heckel, let me question you on this. See if you can fill in the blanks here. When you provided the justifications, did you provide them for the record here today?
I mean, I think
Did
the
you
record has a lot of the back and forth on the justifications. If you look at page 1340 in his original deck, I don't know if you have that.
No,
It
ours go, well, our page numbers only go up to 712. But I'm asking, I'm just asking, so for the justifications for the redaction, how did you provide that? What kind of document was that?
we provided them in the email responses with attaching the responsive records in the first instance.
And then later on, did you provide them, redaction by redaction?
Yeah, then later on we provided.
And where's that document?
I can't cite to it in the record, but I don't think he's disputing that he received it.
That's not what I'm asking. I'm asking where's the actual document. He created his own table that parsed out the reasons for the redactions. I want to see what you provided to him.
Well, those are the original justifications we provided. I don't think he included in the record the index that we provided in January, because I don't think he's disputing that
But neither
the key.
did, neither,
No, I didn't. But he's not disputing that it was proper. I mean, I could email it to the clerk. It's an email, or I think a series of emails.
Is that correct, Anonymous?
I think there's some confusion over words here. They have never done the actually go into a PDF and code each redaction. The text they gave me is exactly what you see in the rightmost column. They said the words, if you look at the unnumbered page 18 of the PDF, the way they provided me an index, it says redactions appearing between, that's their words. I did not create that. That bullet list is from them.
Yeah, but those were, may I respond?
Yes, go ahead.
Those were the original justifications. We provided a key January 16th, as he says in his timeline. I've never heard him once in this whole file dispute that the index was somehow not clear. The index keys every single redaction with every single justification.
I think what he's citing is that, and correct me if I'm wrong, Anonymous, is that at the time that the records were provided, you did not properly cite per redaction an annotation or a footnote or a citation of why or what gives justification for that redaction. Instead, you provided him with just this narrative.
Yeah, I mean, I think in the first place we provided a list of redaction justifications, and as I said earlier, I believe that they were apparent from the context of the documents which redactions were connected to which justifications.
By page number, like page number 2, line 4, line 10.
That's
line
what
11.
That's what we provided in January.
That's what you provided in January, but you didn't provide that in July.
No, because we believed it was clear which redactions were correlated with which justifications.
Okay. All right. Thank you. Okay, members. Time to deliberate. Is there a motion? What do you think?
I have one question just for Anonymous, just to clarify.
Member Yankee.
Anonymous, I understand there's 26 documents that came late. How many documents came on time?
There's 11 different record sets. Each of them may have about 30 pages. So about 300 pages were provided on time. 11 different record sets were provided on time. And then 26 attachments were not provided on time.
So these were attachments to those record sets?
Yes.
Okay.
And they knew that I asked for attachments because they gave.
Okay, thanks.
For attachments.
Is there a motion?
I'll make a motion. There's a timeliness violation.
Under section,
Under what complainant put forward on page 31?
so 6721B,
Correct.
for timeliness. Okay, moved by Member Martin. Is there a second?
I'll second that.
Second by Vice Chair Wolf. Any further discussion? Member Lehood.
Do we feel that the timeliness violation sort of encompasses all of the other issues that arose from that in terms of everything was eventually provided? It was initially incomplete, but so that,
I don't know. What do you think? What do folks think? Member Yankee?
I mean, what I'm trying to think of is, I don't think there's any dispute that there were things late. I think the contention being made is it was, for lack of a better term, a clerical error, that they did their best to produce a large volume of things, and in doing so, inadvertently missed portions of it. So I think, by the letter of the law, I think they did provide things late. But I'm not sure if it was like they intentionally sat on a request for 5.5 months. I think that's where I'm struggling. I think they did their best to turn over what they had, and in the course of back and forth review, realized that certain things had been left out. And so, I don't know, I mean, is a clerical, I guess the question I'm trying to think of, is a clerical error a violation? Or since it came eventually, and it seems to, be a very small minority of the total records request, is that just, good thing we found it, and, Anonymous pointed it out, they eventually found it and included it. That's kind of where I'm personally struggling with this one.
And what about the redactions? I mean, I'm a little moved by that, a whole narrative, more narrative. Now, frankly, I'm not looking at the original documents. They've been parsed out by the petitioner into a grid that is not reflective of the original document. So, and I've asked for that to be pointed out. It's been unresponsive from both parties. So it's a little hard not to be able to see the document and then say, okay, how did that come? Was it a separate attachment? Was it in a cover letter? Was it in a, that kind of thing? So it's hard to point out. We have to do it based upon the evidence and the facts.
I mean, I think I'm a little more moved by the contention by Anonymous that everything wasn't specifically annotated in one way or another. I don't think there's any contention. I think, Mr. Heckel said he thought it was obvious, but I think the admin code is pretty clear that it really needs to be cited. And that I don't think is a clerical error. I think that should have been more descriptive up front, and I don't think that's disputed. So in that portion of the timeliness, I actually tend to agree.
Well, it's not a timeliness issue. It's what happened, what was supposed to happen at the delivery.
Right.
If you're going to redact something, you have to, cite, in some way why that particular word, character, or whole page was redacted. And then the question has become for instance, there are pages that are wholly redacted, and we have no idea what's on the page. And so there's no explanation for that particular page.
Yeah, so I think that's probably under, I see more of a violation of 6726 personally, where it talks about that it should be, specifically,
right.
Like you said at the time, specifically annotated where keyed to the justification. Yeah, exactly.
Right.
That's more of the violation I'm seeing here rather than the timeliness, because I think the timeliness was more of a clerical.
It's our experience too that, when we see redactions, they're usually cited, specifically, and we ask, okay, this one, why was this one redacted? And we got some of that here today for the purposes of the email address. Why was the email address redacted? Well, for, personal reasons. And there is, citations of state law that do cover that under CPRA. So I, but what about the rest of it? Okay, and I think that's what I'm trying to elucidate here.
I mean, I would suggest that we amend the motion to include,
Well, I would.
or unless you want to handle the two issues separately.
Well, I mean, I would rather handle them separately. I mean, I think, for one, I don't see the original document that has the footnotes and the citations. And if I go by the columns produced by Anonymous, the left-hand column, which was first produced, is more wordy and has more bullet points in it. It may not cite exact line demarcations or points in the record, but it does go through and cite reasons for withholding. The one on the right, the column on the right, is more specific in citing where the redactions are and the reason for those particular redactions. 6726 says, keyed by footnote or other clear reference to the appropriate justification for withholding. I would rather do them separate because, frankly, I don't think I'm going to find a violation
then
of
let's do that.
6726.
Okay. Shall we go to public comment? Are there any other points on this? Okay.
At this point, I only have one motion.
It's only one motion right now for.
And I also wanted to clarify, I did note that the title of the complaint listed a large variety of people. I was wondering if the violation is against all of those, or if you'd like to amend the list of respondents. Or just
That's up to
declare
the
office
maker.
of the mayor.
That's up to the maker and the second.
Should we keep it generic as office of the mayor, or do you want to continue to list all the specific names?
I would prefer to just do office of the mayor.
That's fine by me.
Okay. So now the motion is a violation of 6721B against the office of the mayor for timeliness.
Correct.
Okay. Any public comment? Seeing no public comment, are we ready for a vote? Please call the roll.
On that motion, Member Martin.
Aye.
Martin, aye. Member Vice Chair Josh Wolf.
Aye.
Josh Wolf, aye. Member Highland.
Aye.
Highland, aye. Member Hinsey.
Aye.
Hinsey, aye. Member LaHood.
Aye.
LaHood, aye. Tesfa, absent. Member Yankee.
No.
Yankee, no. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Okay. Are there any other motions? Going once, going twice. Okay. Thank you very much. Let's move to the next. Let's take public comment.
Next on the agenda is item 5, public comment. Members of the public may address the Sunshine Ordinance Task Force, a matter that are within the committee's task force's jurisdiction, but not on today's agenda.
It's general public comment for items that are not on the agenda.
Mark Sullivan. Mark Sullivan.
Hold on, we have somebody before you. Go ahead, Mr. Sullivan. No, go ahead.
Mark Sullivan, hello. Most of the time in speaking to you, I can only speak in 5 or 3 minute time intervals. I've been failing miserably. My previous complaints were against Mr. Jonathan Goldberg and Mr. Chris Corgus to show how actively involved the city was in Mission Dolores Green Benefit District formation. These 2 city employees never showed up to any of my hearings. Instead, the custodians of records showed up to the hearings. This allowed for plausible misinformation, as the custodian of records did not have clear knowledge of the contracts, GPDs, or activities of the city employees in the formation process. Furthermore, the custodians of records made arguments that were misleading and included records that had nothing to do with the complaint. At the most charitable, this was unintentional, but I do believe this was a deliberate agency tactic. What it causes for the petitioner is a whack-a-mole situation of countering their arguments while still trying to get relevant points across. Chairman Wolf asked a custodian of record if the Green Benefit District contract and effort was still in effect. The custodian of record gave a non-answer or did not appear to know. The inability to answer simple questions or give incorrect answers benefits the city, not the public, during SOTF hearings. Fundamental rule in California Public Records Act is the presumption of public access. If the public cannot access knowledgeable officials for whom a complaint is against during a hearing, then they do not have access to the public record. Section 6722, release of oral public information shall be accomplished as follows. A, every department head shall designate a person or person knowledgeable about the affairs of the department to provide information, including oral information, to the public about the department's operations, plans, policies, and positions. Knowledgeable is a key word. In my opinion, if SOTF determines that the designated representative is not fully knowledgeable or none appears at a hearing, then you should not vote or issue an order of determination for the city. Each hearing, SOTF is also asking for the public record. SOTF hearings and documents become public record. Transparency of the government relies on records and oral information to be accurate and true. I realize that SOTF cannot force knowledgeable city employees to appear before you, but if they do not, you can vote that the city has violated 6722A. Thank you for your time.
Thank you. Person on the phone?
Phone caller?
Good evening, as always. Hello, can you hear me?
Yes.
All right. Good evening, Anonymous here, as always. Thank you for your work in the last case. I know there's still one more for me. I'm just going to read some quotes from the Supreme Court. Here's one. Quote, to the extent that legislative intent is ambiguous, the California Constitution requires us to broadly construe the PRA to the extent it furthers the people's right of access, and to narrowly construe the PRA to the extent it limits the right of access. And that's Supreme Court in 2013 in Sierra Club versus Superior Court. Now, the city often wants you to do the opposite and say that they should expand an exemption beyond what is exempted in the words of the law. Here's two other quotes from the Supreme Court. Quote, broadly construed, the term, quote, local agency logically includes not just the discrete governmental entities listed in section 6252 subdivision A, but also the individual officials and staff members who conduct the agency's affairs. Another quote, moreover, the broad term public official encompasses officials in state and local agencies, signifying that CPRA disclosure obligations apply to individuals working in both levels of government. And both of those quotes are from City of San Jose versus Superior Court 2017. And I know many people like citing that case about public records on personal property being disclosable, but it also held, very interestingly, that individual officials and staff members are within the definition of local agency that the CPRA enforces obligations on. And that's going to come up in an SFPD case where a single officer has access to records about Brian Carmody's raid, but they claim that that's not a public record. I'm just going to end with this in the Sunshine Ordinance. The people do not cede to these entities, the government entities, the right to decide what the people should know about the operations of local government. And I think given the allegations of corruption currently going on and the supposed claims by supervisors, mayor, and the city attorney about supporting transparency, this task force should enforce unyielding accordance with the law.
Are you finished?
Yep, I'm done.
Okay, thank you. Is there any further public comment? Items not on the agenda. Okay, great. Let's move to the next item.
Next on the agenda, item number 4, file number 19108, complaint filed by Anonymous against City Attorney Dennis Herrera, Elizabeth Cobreth, and the Office of the City Attorney for allegedly violating Administrative Code, Section 67.25, 67.27, and 67.29-5 by failing to respond to an immediate disclosure request in a timely and/or complete manner, failure to respond to a public records request, and failing to justify withholding of records, and failing to maintain a Prop G calendar.
Okay. This was heard in the Complaints and Amendments Committee. Is there anything to?
I don't think there's really anything to add. It's, again, timeliness and completeness, and then the how the Prop G calendars were maintained and what was perhaps not included in it.
Okay, thank you. Okay, Anonymous, are you there on the phone?
Yes, I am.
Okay, we're starting the clock. You have 5 minutes.
Thank you very much. Anonymous here. Good evening, Chair and members of the task force. We're going to begin on page 729 of the record, which is page 17 of the PDF. The summary given just now is exactly right. So I had an immediate disclosure request on October 8th for the calendars of Herrera from September 30th through October 7th. And that's the only part we're going to discuss today. The rest of it is not going to be discussed in this complaint. They invoked an extension on October 15th. They provide what appears to be an incomplete calendar, and I'll show you that later. They specifically said they don't have any other calendars, and they specifically told me that my request was complete. And after I filed a complaint, and after I filed the complaint, they tell me, well, we actually did withhold some information. They provided the justification to attorney-client and work product privilege, and then they provide the locations of meetings. I clearly asked for the location of the meeting. I clearly asked, you can see on the bottom, I clearly asked for the times of the meeting. I asked for Prop G and non-Prop G calendars. I asked for the individual view, not the summary. We're not here, however, to discuss any kind of metadata or ICS file. If you go to the next page, here I've cited 67.29-5. It's a very basic rule. The city attorney shall keep or cause to be kept a daily calendar wherein is recorded the time and place of each meeting or event attended by that official, and there's a bunch of other requirements as well. And this is just one example. This is from October 1st. The full records are later on in this PDF. I don't think that they record locations of their meetings, which is strange because it's definitely part of Prop G. And in a later argument, they're saying, well, we don't have to record locations that are in City Hall. There's no such exemption in Prop G. Prop G has exemptions, and they are for the names of the employees of City Hall employees, but there's no exemption for the place of meetings in City Hall. And clearly, there's this event, speaking at Salesforce event panel discussion. It's definitely not in City Hall, and it's definitely 3 or more business days prior to my request, but they just don't have a location. I'm not really sure why this is the case. They have argued, again, that they just don't have to put the locations unless they're not in City Hall. And if you look at the bottom of this slide, so yeah, they didn't justify why they withheld things until after I filed a complaint. They explicitly told me the record was complete. I'm also alleging, similar to case 19047 from the past, and this is speculation because there's just no way for me to know. And I think someone else did this a few weeks ago. I don't think that this calendar is the extent of all information they have about scheduling for Dennis Herrera. I explicitly said all scheduling items, all calendar items, whether they're on paper or on the computer. I just can't imagine how a person would run a city office if this is the only information. And if you remember in 19047, that's exactly what happened. They had this kind of basic public calendar, and they had the internal calendar, and after a lot of fighting, they gave me that internal calendar. I can't prove it, though. They may or may not have that. Look, we're going to go to page... we're going to go to page 743. These are the actual records they have provided to me from 743 to 750. Those are the ones they provided to me. Only some of those days were 3 business days or more prior, so the other ones don't have to be Prop G specific, but the ones that were 3 business days or more prior do. And if they tell you, well, it's just a mistake in this one case, I have much more evidence of other Prop G calendars from them in the next pages, none of where they record the location of the meetings. So I'm not really sure what that's about. I think they need to record the location of the meetings. And they're going to say, well, there's a rule of reason. That had nothing to do with this request. That was a large 2,000-page request. That is fine. They gave a rule of reason. That was after this request. after they told me this request was complete. So I don't know what that would have to do with not having places recorded in the Prop G calendar. Thank you.
Are you finished?
I'm.
Very good.
Yes, I am finished.
Are there any persons or witnesses providing any facts or evidence on behalf of the petitioner? Seeing none, respondent. City Attorney, Mr. Cote.
Good evening, task force members. John Cote, Communications Director at the City Attorney's Office. I think a little context is helpful to start things off here. So during the time this request was pending before our office, we were in the midst of responding to many other requests from this same anonymous individual. Those included an immediate disclosure request concerning the city attorney's future calendar and 2 other requests for calendar-related information. They also included a 30-part request for thousands of pages of emails and electronic documents from 16 different employees at the office, requests for records showing how we track responses to public records requests, copies of all sunshine-related complaints we have received since January 2018, whether via task force or from some other source, all current and archived copies of the Good Government Guide dating back to 1990, as well as a 7-part request for keyword searches through the email accounts of multiple city attorney staff, requests for information regarding the Fine Arts Museum, and an 8-part request directed to all managing staff across personnel and work accounts for contracts, communications, payments, and other information related to the Foreign Corrupt Practices Act. So on October 8th, we did receive this request from the anonymous complainer here. On October 9th, we wrote back to invoke an extension of time the very next day. So the complaint filed with this task force argues that our response was untimely. We disagree. The extension letter we sent to the requester on October 9th cited a need to consult other departments. This was proper because the October 8 email sought more than just the Prop G calendar. It also sought calendar items and scheduling emails for the Prop G calendar, as well as other calendars that may exist, and also sought future calendars. So on their face, and considered as a whole, the request had the potential to impact other departments with whom we had been meeting in confidence or whose legal matters we may have been discussing. So under such circumstances, an extension to consult other departments who may have an interest in the request was appropriate. We sent our final response on October 15th, which was well before the 14-day deadline. So setting aside the timing issues, the rest of the complaint is based on the same allegations that we addressed in our October 16th email to this complainer. So the first allegation is that we didn't specify the location of each meeting on the calendar. So our October 16th response stated, all meetings took place at City Hall, with the exception of the Salesforce event. Now, we apologize for neglecting to list the street address for that event. That event was at the Salesforce Tower, in which we included the address for in our October 16th email. The next allegation is that the response did not include additional non-Prop G scheduling information. So the City Attorney's Office does not have a non-Prop G calendar for the City Attorney. Our only calendar for the City Attorney is the Prop G calendar, which does not include information such as identity of particular clients or the particular topics discussed due to the attorney-client privilege and work product privilege. The October 16th email that we sent to Anonymous addressed this as well. So the last allegation is one that we did not provide individual meeting items that may be contained in the calendar. As explained in that October 16th email, the calendar does not contain any notes or other information beyond what we already provided to you, and the City Attorney does not use Outlook invitations to set up meetings, so it appears we do not have any further responsive information. The only possible responsive documents we added would have been emails used to set up and confirm meetings on the calendar, but such emails would have been responsive to other pending requests, not item 1B, which is the issue that is before you today. And we timely responded to those other requests on October 18th. This complaint does not challenge those responses, and that issue is not before you today. So I'm happy to answer any questions you may have.
Are there any persons or witnesses to provide any facts or evidence on behalf of the respondent? Seeing none, members?
One thing that has come up in this case, and I've seen come up other times, we're still having city departments invoking a 14-day extension, and it's really supposed to be 10 days.
Right.
And this happens over and over again, and I know we keep saying it's 10 days, and we keep saying 14 days, and I don't know what we need to do to communicate to the city to make sure that people know under the Sunshine Ordinance it's 10 days.
Well, let's reserve what we think needs to be done regarding that for another part of the agenda to have some further
Totally fine with
discussion.
that.
But if it is applicable to this particular case, then I would say make it pertinent with regards to this case. But so duly noted. Mr. Cote, I have a question. 6729-5 is pretty clear, okay? And with regards to withholding of information that might be in a document, that is what redaction is reserved for, not the omission of information. The only other place that records or information can be withheld is by them being exempt. So, for instance, if there was an investigation, the whole file would be exempt, could be exempt under some investigative law, area of law. If it was a personnel file, the whole file can be exempt based upon personnel, areas of personnel law. But if a document is public and is in fact public and is required to have information on it, that information should be on it, and if it's not to be disclosed publicly, then it should be redacted and, as we heard in the last case, annotated with a citation. And that's exactly what this, exactly what 6729-5 requires. So I'm just wondering why it's not provided here. And
What's not provided?
That why the place, the location of these meetings was not included, and if there was a if there isn't a problem that to not have them there, then why not put them there? Why not just follow the law and put it there?
I mean, the location of the meetings was all at City Hall. It was an oversight to not say that in the original response, and we said that in our October 16th response.
Yeah, I get that, but it's not a matter of responding. It's a matter of it's very specific. The law is very specific that it must be recorded in the calendar. It's not recorded in the calendar. So not recording it in the calendar and then, waiting for somebody to ask for it and then providing them a response is not what the law says you're supposed to do. We're here to follow what the law says, and it's written a certain way for a specific purpose, so that we don't end up with having to have this kind of meeting. So that's why I'm a little concerned about that, because everyone else follows this law in the way it is. So, even for the point where it says for meetings not otherwise publicly recorded, the calendar shall include a general statement of the issues discussed. None of that is included either.
I would actually point you to page 745 of your packet, looking at the calendar entry for October 2nd. Our position is that the general summary, when needed, is included. So, for example, look at the meeting at 10:30, meeting with Kate Lazarus and Asim Bonsali, RE introductory meeting. So that's a summary of the meeting, introductory meeting.
What about the 9 o'clock meeting? It just says senior staff. What was that for?
That is a regular senior staff meeting.
There's
routinely held.
There's no description of what it is about. It just says senior staff. There's nobody. The public cannot glean anything from something that it's like just putting a person's name there without any information about what the meeting is about or where it is.
Again, it's at City Hall, and it's a meeting. It's a regular meeting of senior staff.
Okay, thank you.
Sure.
Member Martin.
Yeah. I mean, I think the issue I'm having, maybe you can help me out with it, is it says for meetings not otherwise publicly recorded. So does that mean if there's another record of the meeting, or there's
Like an agenda posted.
right, then they don't have to put that in the calendar? Is that how that reads?
No, for meetings not otherwise publicly recorded.
Right.
So
then,
those are for meetings that are not agendized publicly?
right, then the calendar shall include a general statement of the issues. But if there is, then the calendar doesn't need to
Right.
have that.
So for instance, if, Sunshine Task Force is meeting on February 5th at 4 o'clock, it's posted everywhere. If a public official just had, if any of the respondents here had in their calendar a Sunshine meeting, they don't necessarily have to put a statement of what the issues, might be discussed, because it's publicly recorded.
Right.
And recorded doesn't necessarily mean posted. Recorded means could be in another document in somebody's drawer.
I mean, I think the other, I'm not struggling with it, but I can see how there'd be some issue depending on where the meeting's taking place. I mean, if someone works in City Hall and they never leave City Hall, but again, there's a bunch of departments and what else housed in City Hall, and the calendar simply says at City Hall, that's not very helpful. Or if someone lives in the city, doesn't leave the city, and just says all my meetings are in San Francisco, that's not very helpful. There's thousands of places to meet in San Francisco, obviously.
Right.
But for me, I just don't think saying, especially for a City Hall entity, that we meet at City Hall, that just doesn't make sense to me as far as saying the place of the meeting, or interpreting it that way, I should say, in a rational.
Okay, so I want to hedge your continued narrative to hold it for the after rebuttals, when we can deliberate those issues, because there may be some other information that comes out during rebuttals. Is there any other questions or clarifications needed? Seeing none, let's move to rebuttals. Mr. Cote, you have 3 minutes.
Task force members, I would just reiterate the points that I made in my opening remarks. Beyond that, I think we've covered most of the topics, so I'll submit.
Okay, thank you. Anonymous, you have 3 minutes. Anonymous, are you there?
Yes. Yes, I
You
am.
have 3 minutes for rebuttal, please.
All right. I think, look, they can say all the terrible things they want me. I'm sure they despise me. My purpose is to make sure the city follows the full Sunshine Ordinance as the voters put on the ballot. That's why I make these requests. I'm going to read to you the Good Government Guide, a self-serving document from Dennis Herrera himself that says, for each entry, the daily calendar must include the time of the meeting or event, the place of the meeting or event, a general statement of the issues discussed as long as the information is not confidential or privileged as a matter of law. If a recording of the meeting or event is available to the public, then the official is not required to include a statement of issues discussed. There's other things, but I'm not asking for those things. And I'm just going to go through, I'm going to read to you the proxy calendar of various other department heads. And this is from the head of the contracts department. He had an 8:30 a.m. OCA Seniors Managers meeting, City Hall, room 431. Here's the emergency management head. She had a meeting about street conditions in City Hall, room 200 from 5:30 p.m. to 6 p.m. Here's the Department of Elections. They had a weekly meeting in the director's office from 11 a.m. to 11:30 a.m. The assessor, they had a meeting in the IT room roundtable location from 9 a.m. to 9:30. The sheriff had a meeting from 8:30 to 10 a.m., executive command staff meeting. Sheriff's office, room 456. See, their advice has been followed by all the other city departments. And it's not a fluke that they only did it today. There's months of different property calendar records I've put in the record. They just don't do this. And your chair is exactly right. The public isn't supposed to ask questions. They're supposed to record it in the record. I could just keep on giving you examples. I think this is pretty obvious. Just put the locations in the record. When I ask for them, then we can have them, and we don't have to have these complaints if they just follow the words in the law. I also want to note for the record, I was not noticed for this hearing, so I didn't have a chance to put in additional documents. I'm happy to keep on proceeding. I'm just putting that in the record. I told Ms. Legge, I'll just go anyway, but that's all. I think it's very obvious. They need to just follow the property calendar rules. Thank you very much.
Okay, members, is there a motion or further deliberation? Do you want to continue with your narrative, Member Martin?
I mean, again, from my perspective, putting simply down City Hall as location or nothing at all. I know that it says speak at Salesforce event panel discussion. Well, I mean, I know it involves Salesforce. It's an event. It could be at Salesforce Tower. It could be somewhere else in the city. I just don't. It does not look like that calendar is following the place portion of 65.29-5.
Yeah, Member Yankee.
I would absolutely agree, and to the point I heard raised in the discussions earlier that it was just raised when it was asked when someone said, well, it was in City Hall. I mean, I think in this case, that may have been convenient that they could remember it because it looks like they requested something that was a fairly recent thing. But I think there's a really good reason why it needs to be recorded and why the law needs to be followed, because what if I asked 2 years ago, well, where was this meeting between so-and-so? If it's not recorded, how are you going to remember it? I mean, I think it's easy to say, oh, yeah, we have our recurring senior staff meeting in City Hall, and then, because it's a more of a current event, you can say that. But I think it's, because this is a historical record, and it could be from months and months ago, I think that drives home the point why it needs to be in the record, and it clearly isn't. So I would agree that, I don't see 6729-5 being followed here.
So is that a motion?
Sure. I'll make that a motion. I'll find a violation of 6729-5.
There a second?
Yeah, I'll second it.
Moved by Member Yankee, second by Member Martin. Any further discussion on the matter?
I know you did find violation 67.29-5, but could you state a specific reason for the record?
For place of meeting not being included in the Prop G calendar.
Thank you.
And what about the general statement of issues discussed?
That's what I'm trying to, let's see. Yeah, I think we could add that as well, too. I mean, speak at Salesforce event panel discussion. I mean, I have no idea what that panel discussion was about. So I understand some of them may not be able to include it because the city attorney and some of them might be attorney-client privileged, but clearly it looks like there's some events in here where that should be included as well. So sure, we can say for include in there that it does not also, that the calendar items also do not include a general statement of issues discussed.
I mean, I might have an issue with that portion because it says for meetings not otherwise publicly recorded. I don't know if that phrase has been interpreted before, if there's a recording of that Salesforce panel discussion you can find online somewhere. I mean, I just have an issue with that introductory portion that then says then it's a clause, and then it says a general statement of issue. If it's not otherwise publicly recorded, then yeah, it has to have a general statement of the issues discussed. And I just don't know what not otherwise publicly recorded means.
Right, so that's why the complainant cited 6727, because there's no justification of withholding that information. It wasn't even the fact that it was redacted, wasn't even included. So the information was held completely.
Well, was it even in the calendar?
Well, the question is was there according to 6727, a withholding under a specific permissive exemption under the CPRA or elsewhere, which permissive exemption is not forbidden to be asserted by this ordinance, shall cite that authority. That was not done. Right. So if it wasn't included, then it was exempted.
Right, but I'm saying if it wasn't in there to begin with, you can't redact it.
Well, exemption is not necessarily redaction. Exemption means not provided at all. Like, it's not required to be provided.
Well, I think it could be interpreted, but they weren't even required to write it down.
And the question then is that correct?
I don't know.
Well, that's that's what 6729-5 is all about. Are they required under 6729-5 to actually include that? I think based upon your narrative and Member Yankee's narrative and some of the discussion we've had here, the answer is yes, they must include it.
I would say yes, they would if it's not otherwise publicly recorded. I mean, it says for meetings not otherwise publicly recorded, then it says the calendar shall include a general statement of issues discussed.
Right.
But I can't ignore the for meetings not otherwise publicly recorded.
Yeah, but that's like saying if I requested an email and you only provided me with the headers of who it was from and who it was to, and not the body of the email, okay, then that body of the email has been exempted. If it would just got cut off there, or if it was just blank, it was just left blank.
Right. I mean, I think that's where I might be misunderstanding, because my understanding is that there's nothing that is being redacted. There's just nothing there.
I hold that there's a difference between redaction and exemption, as I explained before. It's one thing to withhold records that are exempted from being produced, or information that's exempted from being produced at all. Okay, and so then the paper would be. It could either you don't have anything in your hand because it can't be handed to you. Or disclosed, or the information on the paper isn't required to be disclosed. So you'll end up with something blank. But 6729-5 says that information must be there. And if they want to cite that there's some reason that it should be withheld, then you would use the redaction of blacking it out, and then you have to cite. Either way, you have to cite why it's not there. So in your, would you say then, would your remedy be that they had put something on there that said this was otherwise publicly recorded? Yes, they would say agenda posted, or please find in file cabinet number A, file number plus so-and-so, wherever it is. I mean, you have to know, that's the purpose of it being publicly recorded. You have to cite where it is then, to prove your innocence, that there's no violation. If you're not going to cite anything and there's no justification, then there's no justification. Member Yankee.
Yeah, just to get off the specific one, because the Salesforce one sounds pretty public, but just to make it like, using another example, if you go to page 763, at 3:30 it just says MTG with Mayor Breed. Okay, I'm pretty sure that's probably not a public one, and a public recorded meeting doesn't say the issues that they discussed. It doesn't say regarding legal issues, it just says meeting. So, for example, in that one I would expect issues discussed, for example.
And the other thing that's interesting to me is for this particular section of the Sunshine Ordinance, 67.29-5, it specifically specifies the city attorney. You don't see that everywhere in the ordinance with regards to requirements to provide information. It says the mayor, the city attorney, every department head. It doesn't even say the Board of Supervisors. Okay? So for some reason, this is very specific. There are other certain officials that aren't listed here. The treasurer, the assessor, the public defender, not listed by name or by title, but the city attorney is specified there. That is, to me, is pretty significant with regards to it being codified in law like this. So that's why I would say hold a higher bar. Especially, and the petitioner is correct, that it has been cited in the Good Government Guide. And everybody, if everybody, well, I shouldn't say everybody, I don't know, but many people, many calendars that have come across our desk here have had a lot more information than what this calendar is. And Prop G calendars was a pretty big deal. So I'll leave it at that. If there's nothing more on that, then I'll call for public comment, and then we'll move on. Okay, is there public comment on this motion? Seeing no public comment, are we ready for a vote? Okay, please call the roll.
Just to confirm, this is a motion to find violation of 67.29-5 for failure to note the location of the meeting in the calendar, and that is the only.
And for meetings not otherwise publicly recorded, the calendar shall include a general statement of issues discussed.
Thank you.
Excuse me, task force members, if I may make one point.
It's inappropriate at this point.
Sure,
We're
I'm just
beyond
asking.
I'm sorry, we're right in the middle of a vote.
Well, it pertains to the vote, and specifically it's the issue of if you do vote against this, I would just ask you to limit it to the office, not to specific individuals.
Well,
May I respond since he has spoken?
sure, short.
It says the city attorney, not the office of the city attorney. Dennis Herrera has a personal obligation to do this.
So yeah, I would say the city attorney, because that's what is literally, it says in 6729-5.
So you're saying it's implied?
Yeah, I would say, yeah.
Okay.
So
Very good.
there shall be, we did list other names in the title, so the complaint, the violation would be against City Attorney Dennis Herrera, specifically.
Well, it says the city attorney in 67.29-5. So whoever the city attorney is at this particular point in time, that's who it's against.
Yep,
Yes.
I agree.
And we will not list the other names on the complaint. The complaint is against the city attorney. On that motion, Member Yankee.
Aye.
Yankee, aye. Member Martin.
Aye.
Martin, aye. Member Hinsey.
Aye.
Hinsey, aye. Member LaHood.
Aye.
LaHood, aye. Tesfa, absent. Vice Chair Wolf.
Aye.
Wolf, aye. Member Highland.
Aye.
Highland, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes. Next on the agenda, we have a series of complaints. Would you like me to read all three of them at this time? They are associated.
Yes, please read all of them at the same time. First, let's just ask, is the petitioner Mary Miles present? Are the respondents present? So we have Mike Salaberry, San Francisco Municipal Transportation Agency. Are you present?
Caroline Sly is present, custodian records for SMFTA.
Okay. For this case?
Yes.
Ms. Salaya? Okay.
Yeah.
Will Tabahanda?
Works at the SMFTA,
Okay, and Luis Montoya?
also no longer employed.
Okay, so you're representing for the SFMTA on this matter?
Yes.
for all three? Okay, let it note for the record that Ms. Celaya from the San Francisco Municipal Transportation Agency is the respondent for all three cases. Okay, go ahead, Victor.
Item number 6, file number 17079, complaint filed by Mary Miles against Mike Salaberry, San Francisco Municipal Transportation Agency, for allegedly violating Administrative Code Section 67.25 by failing to respond to a immediate disclosure request in a timely manner. Item number 7, file number 17080, complaint filed by Mary Miles against Will Tabajando, San Francisco Municipal Transportation Agency, for allegedly violating Administrative Code Section 67.25 by failing to respond to an immediate disclosure request in a timely manner. Item number 8 is file number 17081, complaint filed by Mary Miles against Luis Montoya, San Francisco Municipal Transportation Agency, for allegedly violating Administrative Code Section 67.25 by failing to respond to an immediate disclosure request in a timely and or complete manner.
Okay, the reason why what we're going to do here is the issue at hand is Ms. Miles has requested continuance going back to, I think it was August of 2019, and had made 3 additional requests for continuances, which we had agreed to. She has responded that she feels that this is a long-standing case, which it is. It goes back to 2017, and that it should be heard in the public's interest. So, a little background. This case was continued back in 2017 because there was some disagreement between task force members as to whether individual custodians who had very specific information where the representative did not have the information should appear, and that custodians have an obligation to do that when there's specific information that they and only they can answer. And so it was then referred to our legal counsel to provide some advice for the task force. That was done, but it was sometime later, much later. So then we proceeded to then put it on the agenda, and then subsequent to that, Ms. Miles had requested multiple continuances. It's my concern that if we continue to allow that, it creates a trend and it creates an unfair opportunity. And that if what we can do, I'm suggesting that we do is well, I'm putting it before you, but my suggestion is that we close all the 3 files. If she wishes to refile those cases, then she may do so. And, the process will have to go again, but it will demand attendance from the petitioner, the actual complainant, to do so. So that's what's before us. And because the petitioner's not here to, and these are all 3 cases these were continued cases, right?
They were all previously continued at
Mr.
some
Young?
point.
Okay, yeah. So they were all previously continued. So we already had been in the middle of the process as it was. So now we're being asked once again for these cases to be continued. So it's at your disposal at this point to determine what to do, or our disposal.
Just to be clear, when was the continuance requested?
The original continuance, it was heard on December 6, 2017. At that point, the SOTF requested the continuance in order to gather additional information. And over the past, I don't want to give a time frame, but the past couple of months, we have tried to reschedule these, and we have granted additional continuances as we have tried to reschedule.
So the dates that I have, let me see if I can find them.
And we're certainly outside our normal guidelines and parameters, right?
Yeah. I had a bit of a clarification that I had asked Ms. Leger earlier today. Let me see if I can find it. Yeah.
I know
Lindsay.
that in the past we've heard complaints without
There it is.
one of the parties here. Is there a reason we're not doing that in
Yes.
these cases?
Well, it's up to you if you want to adjudicate and move
Right.
forward with the cases. But the it's one thing if folks don't show, and if you feel that it's within the public's interest to do that. In this particular case, she was asserting to and making an actual request for a
Okay.
continuance. So if you want to deny the request and hear the cases,
Okay.
it's up to you. Sure.
Yeah.
So let me see what the dates are here. So it looks like she requested a continuance on September 20th, 2019, November 14th, 2019, and January 27th, 2019. And supposedly there was one more in August, and I didn't get a date for that one. Oh, August 7th. So four requests for continuance that have all been provided.
And then, Chair, what
Yes.
was the suggestion?
The suggestion was to close all three files, and if Ms. Miles wants to, she could either file for reconsideration of our decision, or she can refile them as new.
Okay, I'll make a motion to close all three files.
I'll second the motion.
So moved by Member Martin, second by Member LaHood. Any other discussion? Public comment on the motion? Close the files. Go ahead, Anonymous, on the phone.
Yeah. Yes. So, I think this makes sense. The complainant shouldn't get multiple years to delay, but I do think the issue is an important one, the underlying issue. It's very rare that I'll say this, but I actually agree with the city. I don't think individual people should have to respond directly. It's just that their records should be, even if it's only one person who has access to that record, they should have to provide that. That's all. Thank you.
Any other public comment on the motion to close the files? Seeing none, please call the roll.
On the motion to close the file and take no additional actions on them, Member Martin.
Aye.
Martin, aye. Member LaHood.
Aye.
LaHood, aye. Tesfa, absent. Member Josh Wolf. Vice
Aye.
Chair Josh Wolf.
Aye.
Wolf, aye. Member Yankee.
Aye.
Yankee, aye. Member Highland.
Aye.
Highland, aye. Member Hinsey.
Aye.
Hinsey, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Okay, I'm going to request a 10-minute recess. Any objections? No. Seeing none. We'll recommence at 6:30.
Next on the agenda is item number 9, file number 19076, complaint filed by Maria Shulman against Animal Care and Control for allegedly violating Administrative Code, Section 67.21, by failing to respond to requests for public records in a timely and/or complete manner.
Okay, complaint committee. Member Martin.
Yeah, this involved, I think, records about, I think the subject of the records was dogs, but there's also the records were sent to like an email that wasn't the right email for the person, and then there's, was everything that was requested sent, and there's a time issue as well, if it was in the 10 days or not. But there's a rogue email, an email address that apparently stuff was sent to that no one had access to. The email address, I mean. So that's...
Okay, are both parties here? Okay, animal care and control? Okay, great. Okay. Okay, petitioner? Ms. Schulman? You have 5 minutes.
Hi. So my complaint has to do with really the timing. My records request wasn't responded to within 10 days. And yes, I filed the request on in 2019 on June 23rd and did not receive a response. I followed up on July 9th, and then the person who responded to me said that they had sent an email to me, but that's not my email address, the UCSF address, and I don't know how that mistake could have been made, because I made my records request through email, and I had made a records request previously, just a week or two before, and gotten a response to my correct email address. And yeah, also when on July 9th, I hadn't gotten all of the records that I requested. But now I mean, I can't say that there are relevant records that exist that I don't have, because they might exist and I just might not know about them. But I got one additional document on July 10th.
No, for the record, the petitioner has stepped away from the podium. Are there any persons or witnesses to provide any facts or evidence on behalf of the petitioner? Seeing none, respondent.
Good evening, members of the Sunshine Task Force, Ms. Schulman, and members of the public. My name is Justine Alberto. I'm the current custodian of records with the San Francisco Animal Care and Control. I'm here to respond to the complaint filed by Ms. Maria Schulman in regards to allegedly violating the Administrative Code Section 67.21 for the request of public records in a timely and/or complete manner. I would first like to address the concern of responding in a timely manner. On June 23, 2019, Ms. Schulman submitted her initial records request pertaining to this complaint. On June 26, San Francisco Animal Care and Control's former Deputy Director, Diana Christensen, responded with the appropriate documents. On July 9, 2019, Ms. Schulman followed up with San Francisco Animal Care and Control and copied the Sunshine Task Force Ordinance requesting a response to her records request. I replied to Ms. Schulman stating that Christensen provided documents on June 23, 2019. That same day, Ms. Schulman brought to our attention that Christensen sent the response to Schulman's UCSF email instead of the Gmail account that was provided in the request. Ms. Christensen has since retired from the City and County of San Francisco Animal Care and Control, so we're unable to provide Ms. Schulman more information as to why Ms. Christensen sent it to the UCSF email. Since then, as mentioned to the Sunshine Task Force Complaint Committee on September 17, 2019, Ms. Christensen has visited San Francisco Animal Care and Control, and I asked her how she obtained the UCSF email. And to the best of her recollection, the email was provided by Ms. Schulman via phone to Ms. Christensen. The secondary concern regarding this complaint is a complete response. Also on July 9, 2019, Ms. Schulman asked for the existence of additional written communication between Ms. Clara Hoyne and Mr. Thomas Ramage, the initial inquiry which spurred a response from Mr. Ramage. For context, Ms. Clara Hoyne is mentioned in the original records request by Ms. Schulman. Mr. Thomas Ramage is the former public service aide who assisted Ms. Christensen in gathering the documents and responding to Ms. Schulman's initial request. After Schulman's inquiry of the additional document, I conducted an extensive search of any additional documents. All documents have been provided to Ms. Schulman in regards to her June 23, 2019 request. To my understanding, San Francisco Animal Care and Control did respond within the 10 days, and the documents were provided to an email address, which Ms. Schulman provided to Ms. Christensen via phone. At the time, Ms. Christensen was our Deputy Director and Custodian of Records. Also on July 9, 2019, when Ms. Schulman inquired for additional documents, as I mentioned, I conducted this extensive search and provided that document that same day. Both individuals, Christensen and Ramage, are no longer with San Francisco Animal Care and Control. So the complaint against San Francisco Animal Care and Control, it's difficult for us to have Ms. Christensen and Mr. Ramage come here to defend their case because they are no longer with our department. I believe that I personally have a good rapport with Ms. Schulman, and as I've stated, I've provided all the documents which she's asked. That's it.
Now, for the record, the respondent has stepped away from the podium. Are there any persons or witnesses who provide any facts or evidence on behalf of the respondent? Seeing none, members? Member Highland.
Ms. Schulman, could you approach? Ms. Alberto said that she believes that she now has sent you everything that you asked for in your several requests. Is that correct?
I can't prove that anything is missing.
Right.
But I can't point to any documents that specifically I don't have.
Okay. And how much material did she send, just out of curiosity?
I don't have it all in front of me. I think you have that in the document somewhere, maybe 5 or 6 documents, something like that.
Okay.
I could be off. Maybe they're 10.
Okay, thanks.
Ms. Schulman, I have a couple of questions. So I'm looking at the original public request form that I believe did you fill it out?
I think so,
Was
on
this
the
an
23rd.
online form, Monday, June 23rd, 2019?
Yeah, I think I either filled out a form or there was a form maybe available on the Sunshine Task Force website that I used as a template.
Okay. And you requested to be contacted by phone?
Yes.
Okay. You did not provide an email address in this request?
I sent the request by email, so...
You sent the request by email?
Yeah, it was...
But you requested to be contacted by phone about the records?
Yeah, if there were extensive records and it was going to cost a lot to photocopy them.
Okay.
Yeah.
Okay.
But for Virginia, what's her name? Not Virginia Donahue, but...
Christensen?
Yeah, Diane Christensen had previously corresponded with me via email. I had made another records request on, I think, June 19th, and she wrote back to that email address, which is the Gmail address.
Okay.
Oh, she did.
So she had my email.
Do you know in our record here where the email is that you sent this form with?
I
have a specific reason for asking.
I don't, because I don't know what you guys have.
It's a matter of what you sent.
Yeah, I CC'd the Sunshine Task Force on July 9th, and in my response to
I'm seeing a lot of messages between you and our office. I'm looking
Yeah.
for the one that you would have had originally. Let's see here.
So if you find the email that I sent on July 9th to
I think
the
it's
Sunshine Task Force and to
Is this the one on
Animal Care and
1298?
Control.
Yes, I think it's there. Top of 1298 from Google Forms,
Okay, hold on.
Tuesday, July 9th.
Oh, 1290. Okay, 1290.
New response complaint form.
No, I'm looking. No, she's testifying that the form. The question is how did that form get into the hands of Animal Care Control? So if I'm looking at the form, it says I want to see the records. Please call me at the above phone number
Oh, I'm
when the
sorry.
records
I'm
are reviewing. That's why I asked, and she said she emailed this form. I'm looking for the original email that this form was attached to, and the reason why is I'm interested to know if it is an immediate disclosure request.
If you look on 1333, it looks like it might be quoted. It says, "To whom it may concern, I hereby submit the attached public records request to the Department of Animal Care and Control."
Yeah, that's the email I sent. It was not an immediate, it was a 10-day request.
June 23rd.
Okay, so it's just a regular request?
Yes.
Okay, all right. So let's just everybody be clear, this is a standard request, not an IDR. Okay, so we're following 6721 here. Okay, so let's see, so June 23rd. So you sent it from your Gmail account?
Correct.
Okay. How's it that they got your other email account, your email address?
It's very strange. I did not give it to Diana Christensen. I was in the process of quitting my job at UCSF and was not checking that email address, and there's no reason why she would have had it. Maybe she tried to Google me and found out that I worked there. I don't know.
Okay. Ms. Alberto, do you have a response to that?
As previously stated, according to the best of Ms. Christensen's recollection, Ms. Strawman had provided the email via phone. So,
That's not true.
I mean, for me personally, I see how when you're having a phone conversation, it's possible that you could have blurted out an email that you're used to saying. So I was not part of that conversation, so I'm just giving you the information that I am aware of.
That's
and according to our former deputy, it was provided via phone.
Also, at the top of 1331, there is an email from Diane Christensen, and she lists both email addresses. The Gmail.
On 1331? No, they're just, it's Gmail, both of them are Gmail.
Never mind, stand corrected.
Yeah, they're both
I
Gmail.
saw it somewhere else.
Yeah, but that, I'll pick up on that, is that responses from Ms. Christensen are to Ms. Schulman in responding to her records request is to the correct email account. So the question is that if we continue down with those threads, we then go to June 26th, and there Ms. Christensen sent an email to her UCSF. This is on the bottom of page 1332, okay? So it's a little unclear why she responded to on June 22nd to the Gmail account, and then on June 26th, 4 days later, she responds to a completely different email address.
I understand what you're saying, sir. However, we were not part of the phone conversation between Ms. Schulman and Ms. Christensen, and Ms. Christensen is not here in order to speak to the conversation that had happened. And as I previously stated, to the best of her recollection, it was provided via phone.
Okay, so that's her basically her testimony.
Yes.
Okay, thank you very much.
I mean, regardless, they should have responded by phone to her anyway, because that was the original format of the request, right? So
Well, I get that.
this whole email thing is a...
Yeah, I get that. Let's
Could I
surmise
add
later.
one
Let's
thing?
just collect as much information as we can here. Yeah, Vice Chair Wolf.
I'm curious whether you're aware if the department has received any previous email from Ms. Schulman using the UC.
So when we received the complaint, I did research to see whether or not the email from the UCSF email existed in the system through a previous conversation. I did not find it. So I pulled true to what I had stated, that I believe that the email was provided via phone.
Great. Yeah, I mean, I know that if I receive an email from someone with an old email address,
Stores.
sometimes I start to type the name, it'll autofill with that old email address, but it sounds like that old email address wasn't in the system, so...
And I don't know if the city and county email address is tied to any UCSF email addresses, like in regards to the Outlook address book. So I don't know.
Right.
Okay, we have a process. Please be patient.
Could
Thank
I add one note? That we did provide all of the documents which she requested, and we continue to cooperate with whatever else she has requested.
Okay, thank you. Ms. Schulman, looking on the top of page 1335, you have responded to Ms. Alberto here and to our office and to the Animal Care Control General email account. Basically, this is on July 9th, basically asking where she got that email address from.
Yes.
Because that wasn't provided. Did you have a phone conversation with Ms. Christensen?
Yes, I issued a records request. I had issued one previously, and I don't think you have that document. But I had.
That doesn't pertain to this case, though.
Yeah, but that was the first records request that I made to Animal Care and Control.
My question is, did you speak to Ms. Christensen after you made this request?
No,
So
I did not.
All been through email.
Yes.
So you had never had a conversation with her?
I had had a conversation with her by phone previous to this request, where I gave her my Gmail address.
Okay.
I would like to say that I have never used that UCSF address ever. I've never sent an email from it. So
it's like it was created for you by the school,
yes.
and you just never used
I never
bothered
used
to
it.
use it. Okay, very good. Okay, all right, anybody else got any questions, clarifications with regards to this?
Yeah, just to follow up on yours, so to clarify, the public records request form that you submitted, I'm looking on page 1309, and you check the box that says, I want to see the records, please call me above my phone number. So you're saying that she never called you at that phone number in response to that particular one?
Right.
Okay,
correct.
so there was no phone call. Gotcha, okay.
Yeah, the response obviously was by email.
By email, yeah.
Yeah.
Just wanted to make sure.
Okay. All right. Vice Chair Wolf.
I don't understand how this is possible, because what I'm hearing is that the email was sent, the public records request was sent by email at a certain email address. There was no phone call. So how on earth did this UCSF email address ever,
I think it was intimated that this custodian had looked it up on the internet, just did a search, a web search, and found.
Right, but that doesn't make sense when you have an email that you received. It's so much easier to hit reply to an email than to Google an email address.
The record is showing that she, in response to, let's see, where is it? Page 1330. Let's see here. 1327. No. Oh, no, that's our office. That's July 15th. Well, the chronology is that on June 26th, nope, it wasn't June 26th. It was June 22nd. Oh, hold on, Ms. Schulman, you said you made this request on June 23rd.
Yeah, and I think in the form I mistyped the
wait
date.
a second.
I sent the email making the request on a Sunday, and I dated it for a Monday, and it's a date that isn't Sunday the 23rd wasn't a real date.
Hold on. There's a bit of an anomaly here.
Yeah.
Hold on. Starting on page 1329. Okay, we have a response from our office. Okay, and if you scroll down below that message on page 1331, you'll see a message from Diana Christensen to maria.schulman@gmail.com. That's in the record. And that's on Saturday, June 22nd, 2019. And it says, Dear Ms. Schulman, I'm responding to your June 19th, 2019 request of records.
You do have that, yeah. So that was the first records request that I made.
So we're talking about a subsequent one?
Yes.
Okay. So also note for the record that she had been responding already prior to the second request to Ms. Schulman at the Gmail account. Okay? So it was already, Ms. Christensen already had that going on. And then on June, but it seems like and then on the bottom of 1332, I don't know whether that is part of the message prior. It's hard to tell the way this is organized. There is a message from Ms. Christensen to the UCSF account. That's on June 26th. And then so these are not, these are now in proper chronology. Then on July 10th, we have a message, the first message from Ms. Alberto to Ms. Schulman at the correct email address. Now, let me ask Ms. Alberto, how did you arrive to get the correct email address at that time?
When Ms. Schulman had responded saying that she did not receive the records on July 9th, I had found the response which Ms. Christensen provided, and then at that same day, Ms. Schulman stated that it was sent to her UCSF email.
Okay, great. Thank you. Okay, anything else? Questions, clarifications? Nope. Should we go to rebuttals? Okay. Ms. Alberto, your first 3 minutes for rebuttal.
First, I wanted to point out that there's no proof on when the phone conversations occurred. I think that it's possible they may have had several conversations in between trying to sort through several other sunshine requests or other hearings and topics available. We provided the documents to Ms. Schulman within the 10 days. It is not SFACC's practice to search or Google any person who is requesting information from us. Quite frankly, we wouldn't have the time to do so. And even if it were, I don't even know if the UCSF email is discoverable through a Google search. So again, as stated, we did respond within the 10 days. When Ms. Schulman brought it to my attention that the information was not provided to her, I did a thorough search and I provided her the documents that same day. The complaint is against the Department of San Francisco Animal Care and Control, though those two people who had worked on her request are no longer with our department. That's all. Thank you.
Thank you. Ms. Schulman, you have 3 minutes on rebuttal.
So I maintain that the documents were not provided to me within the 10 days. You can see from your records that Ms. Alberto provided one document as late as July 10th, and that's certainly not within 10 days. I maintain that I did not have a phone conversation with Diana Christensen anytime after the records request of the 23rd. And I don't know how she would have gotten the UCSF address. Maybe she didn't Google me. Maybe she's just being sloppy in her job. I don't know. And also, yeah, I don't know how it works in terms of, since Diana Christensen isn't in animal care and control anymore, I don't know. That would be up to the task force to decide how to handle it.
Okay, note for the record that the petitioner has stepped away. Members, time for deliberation.
I just want to put on the record that, having been on this task force for almost 8 years, I've come across Ms. Christensen several times, both in her capacity at HSA as well as ACC. I found her to be very good custodian of records, very prompt, very accurate, very detail-oriented. So I certainly don't think there's anything intentional here. I just wanted to state that for the record, for her character, from my perspective.
Anybody else? Now, I have one thing on page 1332. Even if Ms. Christensen got the right email address, read the response to the request. I'm writing in response to public records request we received from you on June 24th. We have nothing responsive in addition to the emails we sent you on June 21st. Okay? Now we hear testimony that there are records. And once Ms. Alberto or whoever took up this case after receiving a message from Ms. Shulman subsequent, later, I guess it was in July, now all of a sudden they have records. So I'm concerned about that. And I don't know whether, it's hard to tell also whether this is a message regarding, whether something got mixed up in the communication, since both requests seemingly were pretty close together. But were two completely independent requests. Vice Chair Wolf.
It seemed like mostly what we heard was a complaint of timeliness, as opposed. I'm a little confused about what you just brought up about the records, because we have two very related cases. So there were records, or not cases, two related public records requests. There were apparently records provided on the request on the 19th, but then no additional records with the request on the 23rd is the way I read that. So I don't know whether the records that we heard referenced earlier are actually in reference to which of those two requests.
Well, if you read it, the first sentence is regarding the second request, okay? And then the second sentence is, I suppose, related before then. It says, we have nothing responsive in addition to the emails we sent you on June 21st. That was prior to the second request.
Right.
So she made after the first request, and she got a response, okay? She got an email response before June 23rd, that the first request, they had no responsive records.
No, the first request they gave something, and then the next request says we have no more responsive records.
It says here we have nothing responsive in addition to the emails we have sent you on June 21st. So she got some things in the first.
Right.
And then she asked for more. She had a second request on the 23rd for more or other information.
Right, and it sounds there's.
And it says here that, that's what's a little odd to me in this, that what the response is supposed to be.
You could just read it as, we have nothing in response in addition to the response we sent you on June 21st, rather than the response in the email we sent you. And don't read it as materials, because if you go back and read top of 1326, it is confusing. It says, explain that neither Mr. Chris has any correspondence, including emails, text, copy, and quotation marks. Then the following documents were also provided to Ms. Schulman. What documents?
But I mean, from where I sit, what I've heard is a case about a timeliness violation. We haven't really heard much about whether additional records were found after that point. It seems like there was this response that got sent to the wrong address that would have been within the timeline. And to me, we haven't heard any testimony that this was an intentional mistake. And so a good parallel about whether this would be a timeliness violation is if someone asked for a public records request and then someone didn't pay attention and transposed two numbers on an address, and they didn't get their records because the city worker wrote the address wrong. Is that a timeliness violation? Because the records were put forward to the wrong box within the time zone, and I just don't know how we deal with basically sending it to the wrong address.
I'm not following you. What do you mean in the wrong time zone?
In the timeline, not time zone.
Oh, okay. But we're not talking about transposing a couple of letters. There's a big difference between gmail.com and ucsf.edu.
I mean, of course there is, but the people involved in that mistake weren't here. And like, I don't really think it's a timeliness violation. There may be something else in the Public Records Act about not putting things in proper order. I haven't seen it, but to me, this doesn't really seem like a timeliness violation because the city responded in time and then sent it to the wrong place.
I get that. The problem is if this happened 2 years ago, I may be inclined to, go down that road with you, but this just happened last year. Like just, it just last summer.
I mean, again, I'm not saying there isn't a violation. It doesn't feel like timeliness is the issue.
I think we've used 6721 for past cases where, for instance, departments haven't had a covering email if someone's on vacation, that kind of stuff. I don't know if it's 6721, but basically it's, at the end of the day, the response was not received by the petitioner. Therefore, there's a violation, I think.
And there were records.
But the question is, where does this land in our code?
Well, they are records. I mean, I understand what you're saying. If somebody sent the response, even with the records, to the wrong address, and that's an address that the petitioner doesn't check at all, then it's sitting in a black hole somewhere. So then time goes by and they like, where is my information? Well, we sent it to this address. Well, but I never gave you that address. It's not the address I sent the request in for, and I requested a phone call. I didn't request an email response. And so that becomes an issue. Now the petitioner is saying that they didn't get a phone call. The respondent is saying that the former employee stated to them that there was a phone call. Okay? If you want to go down that road, we could request phone logs. If you're interested in if it's ways to in the best interest of the public disclosure, that's up to us to do if we want to do that. I'm a little confused that how the UCSF email address got introduced into this altogether from the point that the request that was made, and the fact that we heard testimony from the respondent that this email address doesn't exist by their own search in their own directory. So to me, that's conclusive.
It's conclusive of what?
That it's not clear where the Ms. Christensen got that email address from. That it wasn't provided to her by neither the office that she works in through any saved address book or directory or historical account, or by the petitioner, verbally or by email or otherwise. That's, to me, to me is conclusive.
But it's conclusive that we don't know where that email address came from. What is it conclusive of beyond that?
That it was conclusive that it was not responded to appropriately or properly.
I think based on that, I mean, I'm tempted to find a violation of 6721E, which just simply states if the custodian fails to comply or incompletely comply. That's good enough for me. That's basically what happened here, rather than getting down the rabbit hole of how they didn't comply.
What was that?
6721E. I mean, there was a failure. I think we have to note it for the record and move on. I mean, I don't see what much else we can do here.
This is
E?
Sorry, is
Yeah, am I reading that right? 6721E.
If the custodian refuses, fails to comply, or incompletely complies with the request?
Yeah.
Okay.
So, I mean, I think that captures the mistake, whatever you want to call it.
But that's...
Chair, can I
mean, if
ask
there's a
Ms.
better part of the code we can use, I'm open to that, but...
May I ask Ms. Alberto a
Go ahead,
question?
Member Moore.
Somewhere I can step forward. Kind of a compressed calendar. I think it's June 22, and by July 9, Ms. Christensen had left the department.
Correct.
Was that a sudden departure?
No, she was ready for retirement. So we had known that she was retiring, and this was one of the last requests that she was handling.
Okay. And when was her retirement date?
June 26th, end of June.
A lot going on.
Yeah.
And I think that was my big. I just wanted to get a picture and some context of what the office was like.
So we did respond within the 10 days. Unfortunately, it was not to the email address.
Right. Well, I think what's bugging me is where did the email address come from? It's bugging everyone up here.
My understanding is it is a phone conversation.
Well, right. But the problem is Ms. Christensen isn't here to say I called her at this time on this day, and Ms. Schulman's saying I never spoke to her. So I guess if we really wanted to make it a pain, we could say produce the phone records, and we'll see if there was an outgoing call to the petitioner.
Yeah, and I mean, in your own defense, if you think it was a phone call, you should have phone log of, that comes into your system.
You know what I mean? It would help. It wouldn't be determinative because we still don't know what was talked about
within the phone conversation.
Right. Mm-hmm. But it would say, we did call, and perhaps it lasted this long.
I mean, at the same time, wouldn't Ms. Schulman be able to produce that as well?
It's not incumbent upon her to do so. It's incumbent upon you as the respondent, if you find that there is some evidence that would prove your case. Okay.
It's also really hard for someone to prove they didn't receive a phone call because you could have any number of services that send and receive phone calls.
I think what else is just kind of bothering me is that she responds to the other email like 2 days before sending the one to the UCSF. So I picture her wanting to retire in a rush, types in the name, finds it on LinkedIn, finds an email, and sends the stuff. But I don't know. I mean, that's just pure conjecture. So
can I make
the last address
motion?
on your Outlook would be so much easier.
Right, I know. That's so weird about
Unless the unless the email was provided in a phone conversation.
Well, that's a possibility, but we
that's
don't know.
What we're saying is,
Yeah.
tell us if there was one.
I can only tell you the information that I have
I
currently.
understand that. So again, if you would have brought a phone log saying, oh, here we have a conversation on this day between Ms. Christensen and Ms. Schulman, okay, then we have some additional facts that we can go on.
Understood.
May I make a motion?
You may.
I'm going to make a motion that the custodian of records failed to incompletely comply with this request under 6721E.
I'll second.
Moved by Member Highland, second by Member
second.
Hensy. Member Hensy. Any further discussion? Any public comment on this motion to find violation of 6721E? Go ahead.
I just think that I believe there was a violation. In my opinion, I think it's still 6721B, because 6721E, in order to violate 6721E, I think you have to not comply with the Sunshine Ordinance Task Force. That's just my reading of it. I don't think that 6721E is how you enforce you find a violation of that to enforce the rest of it. I would, in my opinion, still 6721B. But anyway, thank you.
Yeah, I'd be kind of compelled to that because 6721E is kind of a process question. It's a procedure question. If they don't comply with B, then you can bring it to the Sunshine Task Force. So it's not really quite of a violation. Again, as I've repeated for years now, 6721, you can kind of start with A, and it's kind of in sequence of it's kind of a process unto itself. Neither one paragraph stands independent of the other. They all are related to each other in a kind of a not necessarily chronology, but in a sequence of activity. So I would agree with that, and I would suggest that the motion be adjusted from 6721E to 6721B.
I am open to that, but if you look at it, it says described in B above. What is B? B is just a record, 10 days, and then specifically it says incompletely comply, which is what we're.
Yeah, but you can't just
jump
take. You can't
Okay.
parse
As
out
I said, I'm open.
half of a sentence.
The maker is going to change it to 6721B.
Secondary agrees.
Thank you.
Okay, so the motion has been amended by the maker and the second to be adjusted to 6721B for the same reasons. Okay, any further discussion on the matter? Any other public comment? Okay, seeing no other public comment, please call the roll.
On that motion, Member Highland.
Aye.
Highland, aye. Member Hensy.
Aye.
Hensy, aye. Member LaHood.
Aye.
LaHood, aye. Tesfa absent. Vice Chair Wolf.
No.
Wolf, no. Member Martin.
No.
Martin, no. Member Yankee.
No.
Yankee, no. Chair Wolf.
Aye.
Wolf, aye. The motion fails.
Okay. Thank you very much. Let's call next item.
Just to clarify, there being no additional motion.
Yeah, there's no additional motion. The motion fails. There's no violation.
Yes,
It's
the
just
matter
no
is closed and no violation is found.
Right. Let's just note that in the record.
Next on the agenda, item number 10, file number 19114, complaint filed by Shane Andreas against Tyler Vu and the Public Defender's Office for allegedly violating Administrative Code Section 67.24, 67.25, 67.26, 67.27, and 67.29 by failing to respond to immediate disclosure requests in a timely and/or complete manner.
All right, good evening, everyone.
One moment. We usually ask for the chair of the committee that heard the complaint for a summation, initial description. Member LaHood?
Yes, I'm trying to recall the details of this.
We get staff
Member
notes
Hinsey, do you
today?
remember?
I don't remember. When did we hear this?
This is number 10.
This was on November 26th, 2019. It's okay, we can just continue
don't
on,
remember
and you
this
can
one at
fill in
all.
the blanks later if you feel that something needs to be added.
Yeah.
Usually we do this just to kind of, with the committee's understanding of what it is. We have our notes from the legal counsel, and there's plenty of information. So let's start the clock and have the petitioner start.
Sure, thank you. And I'm going to just jump right into it and hopefully...
Hold the microphone up to you, thanks.
Thank you. Now I'm going to jump right into it, and hopefully I can help bring everyone up to speed as I go through this one by one here. So, number one complaint, the Public Defender's Office failed to timely respond, 67.25. We sent the request in July, 66 days before we got any response. I think it's pretty open and shut. Second complaint. The Public Defender's Office failed to provide a legitimate justification for withholding responsive documents, 67.27. The response we did get was a blanket attorney-client and work product privilege objection based on what I've heard earlier this evening. I'm not going to get into it other than to say that that is not sufficient. It's not just a justification, it's a legitimate justification. Number three, even if some withholding is justified, the Public Defender's Office violated its duty to keep withholding to a minimum, section 67.26. In fact, we only got maybe, I think, a few emails that were heavily redacted with no explanation. And by virtue of the response, there's an indication that there should be more responsive, even despite an attorney-client privilege and work product objection. For example, they responded ultimately that there were, no documents responsive to maybe, I think, 3 out of 17 of the requests, 3 out of 18. But what that implies is that, at least with respect to the other requests, there are, in fact, responsive documents. So that includes calendar entries regarding any meetings in the Public Defender's Office regarding Thomas Osley. If I heard everything correctly this evening regarding other people's requests for calendar entries, and such documents exist because they didn't say they didn't, then we should have some calendar entries, which we don't. And if they're going to say those calendar entries apply to something privileged, once again, they need to explain why that would be. I can't imagine that attorneys are having privileged and work product conversations over Outlook Calendar or Google Calendar, whatever calendar. It's not the point. All right, so beyond that we have, I believe we're number 4. They refused to produce records specifically identified by the ordinance, subject to public disclosure, section 67.295A, 67.29-7. And what I mean by that is they are supposed to be producing emails, including an employee's private account, having anything to do with communications between public officials regarding public business. Next point, I believe I'm on 5 here. They identified but failed to produce disclosable litigation material. So even if they're going to assert attorney-client privilege and work product, section 67.24 states there is, and I quote, an enhanced right of public access to certain litigation materials. 67.24, boy, there's so many subsections here. Let's see, we got B2, is when a litigation is finally adjudicated, we get all the information, even settlement communications with the adverse party. So they objected, hey, we might some of the stuff might pertain to current or future cases, but what about past cases, which is clearly discoverable? And we got nothing. Under the same section, the record of any confirmed misconduct of a public employee. We got nothing, despite, as I said earlier, based on their responses, something must exist. Because they said some, there's nothing, which implies for others, there's something. And it's hard for me to fathom an attorney-client work product privilege when every single one of our requests involves complaints about public officials, namely district attorneys or public defenders, not their clients, not anybody who was being prosecuted. Again, that goes back to the legitimate explanation. We have none. And that, I think, might be all. Yes, thank you. Perfect time.
Still have 30 seconds.
No, can I keep it? Can I push
No,
it forward? No, we don't get to do that? Okay, no.
We don't
that's
yield
fine.
back time here.
No, I think I'm good unless you have any specific questions right now in that 30 seconds.
We do that in the next part.
Okay, thank you.
Are there any persons or witnesses providing any facts or evidence on behalf of the petitioner, the complainant? Seeing none, the respondent? You have 5 minutes.
Good evening, members of the task force. My name is Tyler Vu, and I'm the information officer for the Public Defender's Office. I want to start first where I last left off with this board here, with a comment by Anonymous, who expressed concern about the quality of representation that a poor person gets just because they need help from a public defender. And really, there's really about two kinds of good governance going on here, and they're oftentimes in conflict. One being a good governance of transparency, of openness, of being able to see how officials operate. And the other is sort of the good governance of being an effective representative for people who are poor and are charged with a crime. And those two things go sort of, they oppose each other. Because on the one hand, if you are a private person and you can afford an attorney, that attorney has complete leeway to gather information about the opposition, to gather information about police officers across multiple cases across years, and use that information for the benefit of a private client. If you are a poor person and you rely upon the public defender's office, because the public defender is public, the public defender could theoretically be subject to a sort of request that you see here before you. And that request would then have sort of a chilling effect upon the entire office in terms of how it represents clients. And that's sort of the situation in the Coronado case. The situation which I believe is before you in terms of your briefing is in the Coronado case, the police department tried to gather essentially what is opposition data that the public defender's office had been collecting about police officers in their work with the public defender's office. And what the court in the Coronado case said was that the public defender's office is unique in the sense that even though it is a state agency and it is subject to public requests, public information requests, its function is a primarily private one. And what the court was trying to do was basically say, look, just because you're public and you're poor, you should have the same rights of advocacy that a rich person would have who gets a private attorney. And so what the court said in Coronado was that the public defender's gathering of data about police officers was part of a private function. It was not part of a public function. Just like the information that petitioner is asking for, information about DAs, that's also part of the private function of public defenders gathering data in the course of representing their clients. Now, does that mean that every single public records request by the public defender's office can be, objected to based upon the Coronado case? Of course not. And we're not trying to say that. And in fact, in the records that we did provide to petitioner, items that the petitioner asked, so for instance, item number 1, the petitioner had asked for documents relating to an article by Heather Knight and the public defender's response to that. We did, in fact, provide emails, meeting minutes, meeting agendas where we did talk about the Heather Knight article, and we provided all of that information to the petitioner. But the items that are not public in nature, the items that relate to the information that we collect in the course of representing our current clients now, information that we collect for the purpose of representing future clients, notes on district attorneys, complaints on district attorneys, behavior by district attorneys, that's consistent with the type of data that was available in the Coronado case about police officers. And so consistent with the Coronado decision, we told petitioner that, in fact, we did not have any documents that were public that responded to his request numbers 3 through 15, 17, and 18. Now, with regards to number 16, which petitioner mentioned about calendar entries, in all due to make sure that we did cover it, we did look into our database, and we did not find any calendar entries with regards to number 16, Mr. Thomas Osley. And in our letter to the petitioner on October 4th, we did in fact specifically say we did not have records responsive to the request.
Thank you. Are there any persons or witnesses providing facts or evidence on behalf of the respondent? Seeing none. Mr. Vu, I have a couple of questions here. Is Mr. Osley a department head?
Mr. Osley? I'm not aware as to what Mr. Osley is. All I know is that...
Does he work for the PD's office?
Mr. Osley works for the... as based upon an email that was sent from petitioner to me, that email indicated that Mr. Osley was a district attorney.
Okay. So the calendars that the petitioner is requesting, are they only pertaining to Mr. Osley?
I believe that number 16 specifically requested calendar entries pertaining to Mr. Osley.
Whose calendar?
Every single public defender's calendar.
Okay.
And we did do a search, and we did not, there were no hits on calendar entries that pertain to Mr. Osley. And we did tell the petitioner that.
Vice Chair Wolf.
So let me just try to understand this correctly. So Thomas Osley, Sleeman Nawabi, Alana Solomon, Sangeeta Singha, Matt Soderson, and Roberta Evangelista, none of those people work for your department. Is that correct?
That is not correct, sir.
Okay. Which of those people work for your department versus other departments?
Sure. So I can start with number 5. That's Mr. Sliman Nawabi. Ms. Alona Solomon works for our office. Ms. Sangeeta Singha no longer works in our office. Mr. Soderosen does work in our office. Roberta Evangelista is not a person, is actually Robert Evangelista, so that's a typographical error, I believe. So that's from records 6 through 9. I can number 10, she does work at our office, Alana Solomon. Number 11, Anissa Sir does work in our office. Number 12, Tanette Smith does work in our office. Number 13, Bonnie Chan does work in our office. Number 14, Faraz Halawi does work in our office. And number 15, Ariel Brown does work in our office. Number 16, Thomas Osley does not work in our office.
Okay, great. So this is a combination of both documents that are of a vaguely HR nature, accusations of misconduct committed by an employee that is in the department, and then also documents pertaining to individuals that are not within the department and could be a counter, a foe in a court case.
Yes.
And so it seems like we have, as best I understand your description, that a big law firm essentially is able to gather all sorts of information that they could use as a catalog to assist their cases as sort of an ongoing research of stuff that they can play with. Was that essentially what you were referring to about the difference between a private law firm? Was that?
Yes.
Great.
And that was also what the court talked about in Coronado as well.
And so essentially what we have here is the equivalent of information that may not be exactly a legally lawyer-client confidentiality, but is essentially the equivalent of like information that protects the business health of an enterprise. I believe you may have used the word opposition research, but it's stuff that is being gathered by the public defender's office to assist their clients, but would only assist them in the event that it didn't get out. Is that essentially what I heard?
Well, what the Coronado Court called it was private function. The idea is that it relates to the private work of the public defender's office in representing in representing individual clients, as opposed to, for instance, the chief of the MTA working on behalf of the general public. Whereas in our case, our duties, although we are a state agency, our duties of loyalty and our duties of advocacy are directly towards the individual. And so we have a duty to collect information on behalf of both the current one that's before us, but also the ones that may be coming in later.
But how are allegations of public defender employees' misconduct part of that?
Because most of those allegations are allegations, in fact, all of them are allegations that reside within the actual conduct of representing clients. We don't have any allegations of misconduct outside of the context of them representing their clients in court. For instance, we don't have allegations of misconduct of not coming to work on time, or misusing city funds, or not filling out the proper paperwork when they want to expense an event or expense transportation. All of the misconduct that we have are sort of misconduct that occurs in the course of me, for instance, representing somebody here and saying something in court, taking notes down, and then someone else in court saying, well, you've done some kind of misconduct. It happens sort of in court for a specific client. And so therefore, there is no sort of non-private misconduct that we're tracking that would be available. And that's why I told petitioner that we don't have any materials that were responsive to his requests.
And of that misconduct that is logged, is there a duty to report any of that to the California Bar?
It is not logged. We don't have it logged. They are. If a misconduct allegation is made, it would be in the actual client file. If someone were to make a complaint to the State Bar, that would be one way in which my office would know about it, but that would be separate and apart from a record that we would actually have.
So the records that you have, you don't have an obligation to forward those to the State Bar?
I am not aware of any duty that we forward to the State Bar. Obviously, we do have complaints made by judges against attorneys. Those might be available at the State Bar. But we ourselves, our office, separate and apart from the notes that attorney takes about what happens in court, we don't have any separate database or record keeping of misconduct that would be responsive to this request.
So why isn't it the public's right to know about allegations of misconduct by the legal team that is there for the people who can't afford a private attorney? Why isn't it fair for me to know that there's all these issues, or there aren't issues, or whatever it is? Like, it's important for us as a public to know how our public defender team is engaging in court. That seems like that is a public interest. So why is it not in terms of the way that this request has been made?
Because the scheme of sort of attorney complaint requests that's done in the state of California is done through the State Bar. So, for instance, if you were to do a similar request in the DA's office, right, to say, well, the public has a right to know how their prosecutors are behaving in court, I would wager that they cannot provide the information that we say we can't provide either, mainly because the complaints outside of those made by the State Bar, by judges, or by our office against the State Bar, the complaints are typically made in the common everyday course of representing clients, claims being made to the judge about this person is not doing the right thing. There's so many of them, and that neither side keeps track of how their attorneys are behaving in court, separate and apart from the state bar complaint system, which both the DA and the Public Defender's Office and the judicial branch uses to report complaints about attorney behavior.
So let me add, you keep referring back to Coronado versus Carroll, but that is specific to the private function of the representation of an indigent criminal defendant. That was part of the ruling. Here, the petitioner is asking for information regarding an employee that you may have information about, and that has nothing to do with the client.
Well, except for the fact that the complaint is par and parcel with the representation of the client, and that in order for us to. I don't think you can do that, because we're talking about individual records here. And the question then I have to ask you is, then tell us what records you think are public and which are not. Because then I'm also going to have to ask, is there any jurisprudence or other areas of law that are applicable for those? So we get lots of cases where people will come in and say, well, that's part of an ongoing investigation. It's protected under penal code or under some insurance law or something like that. You're not really providing us with any citation of law. You're providing us with a ruling that we have to decipher out based upon case law. So tell us what, because I'm almost sounding like what you said is many documents should be available to the public, but in this case, not. So what makes this case any different, its records any different than some other case of somebody who is equally should benefit from the same? Actually, what I'm not, I think maybe I should have been a bit more maybe clear or specific. So within the world of the Public Defender's Office and the District Attorney's Office, where two sides, they've got members in court, they're constantly bickering and making accusations about who did what. Mm-hmm. Now, if you are referring to allegations of misconduct about who did what from both sides, what I'm saying is that neither side will be able to respond to a records request asking for that kind of information.
Why not?
Because neither side keeps it.
Okay. That's an answer about responsiveness. Okay. So that's what I'm saying is, if there are records, if somebody wrote a memorandum saying to their superior, saying, I was in this part of the case that I was representing the client, the prosecution was acting in an inappropriate way, and I'm memorializing that for the record. Well, that's information that could be disclosable.
Actually, Chair Wolf, with all due respect, I don't think that information should be disclosable. And I think let me try to convince you as to why. Imagine being a lawyer that knew that if you wrote a memo to your supervisor about Mr. Jones's case, and that you listed the reasons why the district attorney was misbehaving, and the strategy of your case, right? If you knew that record would now be discoverable under a public records request, you're not going to write that memo. And because you won't write that memo, that means that you as an attorney are going to sort of minimize the level of advocacy you're going to do in making sure that the office knows about this bad district attorney. Now, contrary to a public defender, if I worked for a private law firm, I'm going to do it. I'm going to write that memo, and I'm going to make that memo as colorful and as explicit as possible so that my private attorneys can share it freely. And that's the kind of, I think that's the kind of that's the kind of representation that Coronado is trying to protect by saying that communications amongst attorneys, collecting the information, making reports, sharing that information, telling their supervisor, that information should be shared freely to preserve equal representation of poor people when compared to people who have the means.
So let me ask you this. In what part of the course of your work, in the course of litigation before it's been adjudicated or a ruling has been made? Or what about thereafter? The case is now closed and part of the public record.
That's actually, it's actually something that the Coronado Court also addressed. And what the Coronado Court said was that the private function of the public defender's office lives beyond the length of the case. It has sort of two cores. And I'll start with the private function first, which is that in the course of representing client A, and you write a memo to your supervisors about how the DA behaved, that information is beneficial to clients B, C, D, and E later down the timeline. And that public defenders, because of their private function, at the core of what they do is private, not public, it's private, that information is not public, and therefore it is not subject to a records request. Now, I don't want for you to think that what I'm saying is that everything that we do is private and therefore we don't have to disclose it. But what I'm trying to say is that there are certain things that should be disclosed. So, for instance, if the public defender were to have a meeting about policy, about how it's going to treat the DA's office, as a matter of policy, the Coronado Court said that's disclosable. That should be disclosed. If the public defender has a meeting, for instance, wants to respond to an op-ed made in the Chronicle, that's public. It should be disclosed. If the public defender meets, 5 times about a DA in a calendar entry, absolutely, that should be disclosed.
So you're saying that all documents other than what has been made public are privileged?
No. In fact, for instance,
that can't be true. I mean, that would literally defy the not only that Sunshine Ordinance isn't. It just doesn't sit by itself. It is an extension, an enhancement of the California Public Records Act. That would defy state law.
Only to the extent that the material that you are looking for can be categorized as public and with a public function.
Okay, do you provide any defense for that other than Coronado? Because we have to so if Coronado, it's a legitimate, okay, it's a legitimate citation. It's part of case law. One of the things that we have to consider is how it applies to the California Public Records Act. And where there is law that can be cited that excludes or exempts it from the Public Records Act, that's where we come in, okay? Otherwise, it makes it very, very difficult. You're asking us almost to make a decision subjectively as to whether it's a good thing or not. Is it in the best public? Is it within the public's interest, weighing in the public's interest to disclose this information or not? That's a different question. But we first have to look at, is there de facto law that says that this information should not be disclosed, either in whole, like as if it was part of an investigation, or you're in the middle of a case, it cannot be disclosed, or in part by redaction, okay? Or in part by part of the record is exempt, but not the whole record, okay? So we have to consider those things first, okay? And then once we get those out of the way, then we have to think about what weighs in the best interests of public disclosure. And we're going to be hearing about some case law around that, from the State Attorney General, case around the State Attorney General regarding the police department regarding misconduct in a little while. And so it's similar, okay, because here they're asking for information about misconduct, not from people within your office. They're looking for information about people that are not in your office. Just any kind of information. Okay, that's the one thing. Okay, in the police department matter, people are looking for information about people within that department. Okay, so it's different, and so weighing what is in the best interest of the public becomes a little more serious, a little more heavier. Now, the question here is whether the content, I shouldn't say content, the context. It's one thing if the request was all documents pertaining to alleged misconduct committed by a public defender, and you're being asked to reveal that. I would say, maybe that is leaning towards an HR issue. That's a personnel issue. That could be a union issue, okay? But here, we're talking about information that you may have in the course of the work that you do, and with regard, I guess it's regarding a specific case, that is in relation to information that you may have regarding other people that are not connected to your department at all. Do you have a response to that?
Yeah, and in regards to the ones that are not connected to our office, and it's mainly, I believe, before I don't want to misspeak here.
10 through 15.
Actually, yes. So what they're asking for are basically...
And 18, I'm sorry.
Yes.
17 and 18.
17 and 18, which we, with regards to 17 and 18, we did notify petitioner that we did not have any records. Not that they are private or public. We just simply didn't have any records. Again, 16, we did look. There were no records, so we told the petitioner that. With regards to 10, 11, 12, 13, 14, and 15, again, we don't have a record-keeping system pertaining to misconduct by the DA's office, separate and apart from the notes and the allegations that these attorneys may have made in court. And those notes and allegations are sort of so informal and so undocumented that there's really no way of providing those records.
Well, then the question then becomes, are you trying to protect the records, or are you saying it's unresponsive? Okay, I mean, there's that. You're really making a very hard case about trying to protect those records. The question is, do they even exist? Okay, and that's what I'm, it's making it very, very kind of blurry for me to know exactly what you're arguing. So at this point.
Okay.
Go ahead, Member Highland.
Just a side question. I mean, are you saying that your HR department has no records of termination with cause or anything?
No, we don't.
You don't keep any HR records in your department?
We do keep HR records, but they're not responsive. We do have HR records.
Disciplinary records?
We do keep track of those, but they are not responsive to this. They don't exist.
Disciplinary records do exist, you just said.
I'm sorry. They do exist. As a matter of principle, they do exist. As a matter of specific answers to the request numbers.
So if this petitioner recasts his request as disciplinary records for these employees, what would you provide them?
We would look at that. We would look into their files, and where appropriate, we would release them, because they don't pertain to a client.
Okay.
I mean, I think,
Member Martin.
It seems to me, and I'm sure I'll be corrected, that what's being sought here isn't stuff related to specific cases and attorney work product and what's going on between the attorney and the client. What's being sought is interdepartmental communication about alleged misconduct between different attorneys and possible collusive conduct. That's what I see here. So the Coronado is like a red herring. That has to deal with protecting indigent clients and their privacy rights associated with their cases. If attorneys have no way of saying, within the office, I'm being harassed or whatever, and where does that go? It goes in a disciplinary file. There's no chain of command. That's just weird to me. I think that's what's going on here. If you don't have those things, then you don't have them. I just don't see going through a case file and cherry picking things about, wow, this attorney was a jerk today. I don't think that's what's being sought here.
But that's all that we would have. That is all that we would have. But I think to your point though is that even if we didn't have that, even if we had some kind of central database where we would log in the misconduct and the court number, The Coronado case still says that that kind of work is part of the private function of a public defender. And that
Again,
that's
I'm not tying it to a case. I'm saying if an attorney came back and said, met at lunch with this attorney, X, Y, and Z comments were made, inappropriate, not related to any case.
And what I'm asking you to sort of see is that in the Coronado case, none of that material that was collected by the public defender's office was even related to a case. It was news clippings. It was things that were completely some public things, and they were just simply gathering it into a database. And the court said that that database and the clippings that were taken from it, even though not related to a client, those were part of the private function of a public defender's office in defending its client, and therefore it was not public and therefore not subject to a records request.
Let me ask.
Yes.
Let me ask this, okay? I'm just gonna go to what the petitioner had requested of you in their own words, okay? All documents pertaining to alleged misconduct committed by, for anyone starting with number 4 through 18. That's the question that's before you. That was the request, okay? It's records that pertain to alleged misconduct, okay? What was your response to them with regards to that?
That we do not have any public documents responsive to it. That all we have would be things that were part of our private function as a public defender's office.
Okay, great. Mr. Andrus, did I pronounce that correctly? If you step aside for a moment, Mr. Wu. Yeah, don't go too far away. I'm sorry, pronounce your last name?
Andres.
Andres, okay. Let me ask you, is that correct? Is that what you were asking for? All documents, it's actually, we call it records, all records pertaining to alleged misconduct of a particular, committed by a particular person?
Yes.
Okay. If they say they don't have any, if it's unresponsive to them, if they say we don't have any records that specifically has allegations of misconduct that are committed by that particular person, will you take that as the response?
Yes, if that's what they had said, but that is not what they said.
And what did they say to you?
They said attorney-client privilege and attorney work product, and my point was they did say when they did not have documents. They said as much, and we are not here to contest that. But then they said for all these other ones, just a blanket objection with no explanation. And I think I don't have to, I mean, the questions that you all asked are the same questions that I would say are the reason that we're here. Because first, they say there are documents. Well, no, but they aren't really. Well, yeah, we keep records, but we don't. But even if we did, nobody's entitled to them because we have this special, public defender privilege, defend the indigent that somehow precludes them from being subject to the same rules. If there was such an exception, you just put it in the law, just state it. Okay. And that's not the case. And Coronado is as you described it. And that is not what is happening here. That's not the case. And I cited the case that does apply, which is the BRV versus Superior Court. All right? Misconduct allegations, that's why I used the word misconduct, so there wasn't any confusion about definition, related to a public official. I'm not asking for private citizens, not the indigent, not the poor, not any individual in their individual capacity, are the public's business. And so records of allegations of misconduct about public officials are the public's business. So we're asking for it, and they're either saying we don't have it, which was okay, or some objection without any explanation. And the more and more I heard from Mr. Vu, the more I'm concerned that documents are being withheld.
All right. Let me go to the initial request. Your initial request was for documents under what section of law?
I'm sorry, what?
When you made your request, your initial request, I can't necessarily find the original request. Did you make that request as a CPRA request, or is it a Sunshine Ordinance request?
We started with Sunshine.
You started with Sunshine, okay.
We were doing both along the way because, frankly, this was the first step before we file a writ, and we were waiting to get the answer before we file a writ. And so that's why within the papers I filed, I have government code section citations as well as citations to the Sunshine Ordinance.
Okay. And you made your request on
July 26th.
August, I'm sorry?
July 26th.
No. Their request to the
So it's
PD.
dated July 25th, 2019. It was served July 26th, 2019.
And you received a response when? First?
Well, we received, a few redacted emails 49 days later on September 13th. We did not receive an actual written response until 66 days later on September 30th, 2019.
You just started getting a flow of information. Nobody responded specifically saying.
No, it was
Mr.
not a flow of
Andrews-
information. It was several requests for extension, one after the other. And I can highlight them for you, but they're in the papers.
Did you make one request for all this stuff?
Yes.
Okay, thank you.
1396.
I want to find the original request. No, that's our intake form. Okay, I want to find the original request.
I think it's here.
That would be on page.
That was a fax to us, so it's not our intake form. It's just
I think it's on page 1434. The reason why is because we also have to first determine if this was an IDR or whether it was a 6721 request. So it obviously is a standard 6721 request. They have started the ball rolling on a Sunshine request. Okay. All right. Any other questions, clarifications regarding this? Let me see. Mr. Andrews, you are citing what section of the code regarding enhanced right to litigation material? You mentioned that
One
in your
moment. Yeah,
opening
let me-
testimony.
That is section 67.24, subsection B, regarding litigation material, and more specifically, subsections B, 2, and that pertains to past litigation finally adjudicated, as well as section 7, which it starts with the record of any confirmed misconduct of a public employee, et cetera, et cetera.
Okay. All right. Thank you very much. Okay. Anything else for the parties? Seeing none, are we ready for rebuttals? Do we still have quorum? No, we do not. I know. But we should wait until we have it. Okay. Are we ready for rebuttals? Okay.
Actually,
Yeah,
I do
go
have a
ahead.
question regarding for Mr. Andrews for your citing of 6724-7. And this one says what must be disclosed, the record of any confirmed misconduct of a public employee involving personal dishonesty, misappropriation of public funds, resources or benefits, unlawful discrimination against another on the basis of status, abuse of authority, or violence, and of any discipline imposed for such misconduct. Wouldn't that be maintained by the department that employed that person rather than another department?
I'm not. Yes, I'm requesting it from the public defender's office regarding public defenders.
Oh, and okay, so but not for the other people on that list who were not employed by the public defender.
No.
Okay.
And in fact, all of these, I believe, other than Mr. Osley, are public defenders.
Well, it says San Francisco District Attorney's Office.
What does?
I'm reading your list.
No, I know, but from which portion of my list are you reading from?
So, 10, 11, 12, 13, 14, 15, 17, and 18.
No, yes, but you have to read the whole sentence. These are documents pertaining to accusations of misconduct committed by someone from the district attorney's office, but by a public defender.
How does that even make sense, though? How does a misconduct committed by the district attorney's office by the public defender?
No. It's the public defender who's making the accusation of misconduct against a district attorney.
Right, and wouldn't the district attorney's office maintain that information?
Well, yes, they do. And in fact, they maintain it. And I should have said earlier when Mr. Vu said, oh, I'm sure they wouldn't keep it either and they wouldn't provide it. That is false. And so the point is, just because the district attorney has what it has doesn't mean the public, I am not entitled to get the same information that the public defender has. And if he's saying that the district attorney's office has it, just like they should have it, I mean, it doesn't
Why
make
are
any
you
sense.
asking the district attorney's office for information that would be maintained? Excuse me. Why are you asking the public defender's office for information that you know the district attorney's office would have?
I didn't say I know the district attorney has the specific information I'm requesting regarding Mr. Osley. I am responding to the comment that the district attorney doesn't keep the records either, that the public defender doesn't keep. And I'm saying that is not true. Okay, so I am asking the public defender's office for all allegations of misconduct against Mr. Osley. And I am asking in these additional 10 through 17, specifically, those allegations of misconduct made by specific public defenders. That would be within their office. And I forget who said it earlier, but the point is, this is the point. If you have public officials having conversations, communications, right, regarding public matters and regarding other public officials inside or outside their department, that is certainly a matter of public interest. And how else do we get that information? We have to go to that department. And we're going to the public defender saying, we would like this information. And they are saying, I don't know yet, actually. I'm hearing we don't have it, or if we do, you don't get it. And why, I don't know. And we're going to just use this objection, but we're not going to explain to you why we're not giving it to you. There's no privilege log. The Sunshine Ordinance says, hey, even if what he is saying is true, which I have no idea, Mr. Vu, even if it's true, you're still supposed to cut through it and find out what's privilege and what's not. Before me, I'm hearing all the people come up, and we're discussing redactions, right? And we're talking about how do we identify what's what. Exactly. There are very simple procedures for doing this, for letting us know. And if you say we don't have anything, fine. Or if you say we're not going to give it to you because of this reason, fine. But we're entitled to know what that is, not just to have someone come up and say, we're the public defender, we're the Department of the People, and you can't have it. We have some special privilege. And that is exactly the concern with departments like this, with public officials like this, who believe that the law doesn't apply to them. And that's basically what I heard.
Okay, thank you. All right, any other pertinent information that you like? Member Martin, looks like you want to say something.
Yeah, I just had maybe I missed it. Have they provided the calendars?
No.
Okay.
Right, and we'll discuss that after rebuttals. Okay. Vice Chair Wolf.
It seems like beyond the timeliness and these other issues, the biggest thing is that all of the records that aren't being turned over haven't been identified and given a clear reason why. And I'm curious whether, I guess once we have a closing and rebuttals and all those pieces, if there is a violation, I'm just curious what the best way to sort of move this along will be.
Okay, let's wait till after rebuttals.
No, but the reason that I cited it that way at the time that I did is that what we haven't heard is an argument of this record isn't available because of these pieces. We haven't.
I get that, Josh. What I'm concerned about is that we're now making deliberation on those items. If you have a
but I'm very much
question-
not making deliberation on those items. Where I'm at is that we haven't unpacked that.
So do you have more questions to ask in order to be able to unpack that? That's what this particular part of the process is for.
No, I understand that, but it's more like it feel. Okay, how do we do this? I'm sorry. What was your name from the Public Defender's Office again?
Mr. Vu.
Mr. Vu, can you come to the? So I'm curious in terms of this list. Some of these items are no documents existed, correct?
Yes.
Which numbers had no documents, whether they were privileged or otherwise?
I don't want to misspeak, so let me
Yeah, of course.
get my notes together.
Can I assist just for convenience? I'm just trying to, it's in his letter. I'll just point to the exhibit, but
It's your question.
If that's all right with you, from the public defender, can the complainant cite which ones he?
I'm just make it quick. 2, 16, 17, and 18. See? It had no records responsive. And you're right.
Yes, so thank you. Records items number 2, 16, 17, and 18. So in those instances, we did look for the records, and we did not have any records, period.
Okay.
End of story.
So those three, I think we're at. Other than, however, when that response happened, were there any records, any of those inquiries that you were able to turn over all of the records that you had in your possession?
Yes. With regards to item number 1, we were able to provide agenda items, as well as specific emails pertaining to items number 1.
Okay. And so then the remainder, the office has items that relate to the request but have not turned them over due to some sort of particular category why those wouldn't be public documents, correct?
That is correct. And I can cite to the letter in which I cite the reasoning behind the inability to disclose the records.
Right, but what I'm asking is, have the identities of, have an index of records of non-disclosable records been provided? So, in other words, there's 3,000 records, 2,000 of them can't be provided due to this reason, 1,000 can't be provided to this reason. In other words, what I don't understand is whether or not the complainant is aware of the universe of documents he can't have.
Sure. I think that we do not have an index of records that would that could possibly comply with the request, mainly because we simply do not keep a record of the complaints that happened in the course of representing clients.
Although you said, it sounded like you said it would be in each individual case file.
Yes, so we would have to essentially go over 10,000 files a year for the time that these attorneys have been there, and try and figure out if there was a complaint made in the course of representing clients. With regards to the HR files, we don't have any records in HR files pertaining to any confirmed misconduct, like the ones that's cited by task board member Lila the Hood. So it would sort of be impossible for us to provide the known world of what we're not providing.
Right. So in essence, you identified this as a categorical exception before actually going through and going page by page to find the items and then say they're removed. So there isn't a list of all the things that was removed because before doing the research, you identified that all of these things would be not public records.
Mainly because we were relying upon Coronado on the fact that all of the items that come out of representing clients are not public records, that those are client files, case files. I mean, those, as the Coronado case said, are in fact pertaining to the public function of the public defender's, I'm sorry, the private function of the public defender's office.
And in your communication with the complainant, did you say that you have no records outside of what you just described?
Yes, strike that. Let me just state explicitly what I told the petitioner, because I don't want to misspeak. I think what I wrote, our official statement to the petitioner was from September the 30th, and it is on the second page at the very bottom there, where we start with, for the items 3 through 16 above, we have no responsive public records, period. All records responsive to items 3 or 16 were assembled and retained for the purpose of assisting in the defense of existing and future clients, comma, a private function not relating to the conduct of the public's business. Therefore, those records are not public records subject to disclosure. In addition, those records are also exempt based on the attorney-client privilege and based upon the attorney work product doctrine. So we tried to be. I think it's slightly unfair for the petition to say that we simply ignored it or didn't list the reason or didn't tell them that there were records available, and there were the reasons why. I think that our letter from September the 30th state both the reasons why as well as the case law that we cite to as that supports the reasons why.
Great, thank you.
Mr. Vu, just another question or two. In the requested items 5 through 9, I don't recall, you said that those are folks that work for the Public Defender's Office?
Yes, those items 5 through 9 are individuals who work for the Public Defender's Office.
Work or worked?
Yes,
Okay.
yes, work or worked.
Okay.
And
so there could be documents or records pertaining to alleged misconduct. For instance, a complaint about an employee. Okay, how are those handled? How are those regarded?
Sure.
Would those be considered public records?
If it depends on how we arrived at the complaint. So, for instance, I'm hypothesizing. Do you want me to?
I mean, there's all kinds of complaints. There's a whistleblower complaint. There's sexual harassment complaints.
Yes, of
All
course.
kinds of complaints. So, for those kinds of complaints, would those be considered public?
Yes, absolutely, and those would reside in the HR files, and we would treat them as public records. Absolutely.
And would you be able to disclose those?
If there were no barriers to disclosure according to law, we would reveal those.
Okay.
Absolutely.
And for those 1, 2, 3, 4, 5, were there any records, any responsive records with regards to that?
We do not have any responsive records to that request.
Okay.
And that's why in my answer to petitioner, I specifically cited the phrase, we have no responsive public records. And they were all, and I said all records responsive were assembled and retained for the purpose of assisting in the defense of existing and future clients. So in the scenario that Chairman Wolf, task member Wolf mentioned, they would not be retained for they would not be for representing future or current clients if there was a complaint of sexual harassment. And of course, we would have revealed that, according to the logic laid out by petitioner, which is that it's misbehavior by a public official.
Thank you. All right, anything else? Should we move to rebuttal? Okay, let's go to rebuttal. Mr. Vu, you're first. Sorry.
Oh, it's fine.
You're first for rebuttal. You've 3 minutes.
I think I've done plenty of rebutting for the questions, so thank you so much.
Thank you. Mr. Andrews.
Yes, just to close the loop on the end there with what Mr. Vu said, because this is the problem that I'm having. So you either can say no responsive documents or responsive documents, but we're withholding them, you identify them, and you say why. So we can all understand and feel that we are being told the truth, or that this is being done in good faith. And in fact, go back and read the response he just read. It says, there are no responsive documents, period. All responsive documents, right, are public or not public or exempt or because they're, Coronado, whatever. But those are two separate things, okay? And if you're going to say that there are responsive documents that we're withholding, you need to identify them, as someone mentioned, a log. And as far as having to go back through tens of thousands of files, no, the request is limited for that reason, so that couldn't be a concern, from February 1, 2019 to July 22nd, 2019. It's a very short period of time. So there are not thousands of files or records to look at. And even if a database does not exist, lawyers prepare privilege logs. It is not an uncommon thing. It is a very simple thing to do. And so it's neither burdensome nor overbroad. And without it, there will never be any certainty that this particular department is responding to this request by law, which it is required to do. So, thank you.
Okay, members. Now it's time for deliberation and to arrive at a motion.
Public comment?
No, not until the motion is made. Not at this point in the process. So I'm a bit compelled by the petitioner's last statement that kind of crystallized a little bit of the respondent's statement about no responsive documents, but of the ones that were reviewed, they weren't disclosable. The question is they weren't disclosable because they weren't public. They weren't disclosable because of the ruling in Coronado, or they're not responsive because of some other area of law that protects them. And so you can't quite say there's no responsive documents and then say that there is.
Looking at it, it actually says we have no responsive public records. And then he goes on to try to talk about why they're not public records and therefore not disclosable.
Okay, but the question then becomes, tell us how they're not public
record,
right? You got it.
And that's when he cites the Coronado.
Right. And so the question is does Coronado provide an umbrella for all of those documents? But which documents are we talking about? I think that's the question that the petitioner is putting forward. Okay, fine. You want to state that there are documents that are protected by Coronado. Well, tell us which ones. We asked the same thing. Okay, you have a case file that's under investigation. The whole case file is protected. Okay, from soup to nuts. Well, what from prior to the case starting to after the case is finished are you able to disclose? We know everything in between can't be. And because of, you can show that a case began on this date and it finished on this date, and those things would be recorded pretty well. So, the question then becomes, based upon what you just read, tell us which ones are protected by Coronado, and that is that is the proof of burden on the respondent in order to show that they are either not public or they are not disclosable for some reason, either the exemption or redaction. Who had a comment? Member Martin, did you want to say something?
No, I think I was just agreeing with your sentiments. I mean, it's produce it, redact it, and explain why, or produce the privilege log.
It's clear under 6727, I think, justification for withholding. A withholding under specific permissive exemption under California Public Records Act or elsewhere, which permissive exemption is not forbidden to be asserted by this ordinance, shall cite that authority. So the authority that's being cited here is Coronado, but you got to tell us what you're withholding. It can't just be blanket all records. So I think that is, the other parts of that is a withholding on the basis that disclosure is prohibited by law shall cite the specific statutory authority in the Public Records Act or elsewhere. Or C, a withholding basis that disclosure would incur civil or criminal liability shall cite any specific statutory or case law or any other public agency's litigation experience supporting that position. Okay, there's a little more subjectivity there, but still, yeah, we have to know what records we're talking about. Okay, the records that the petitioner is asking for is of kind of a wide range. It could be anything with regards to, as I tried to elucidate with Mr. Vu, was to try to elucidate what kind of records they may be. Are they personnel records? Like a whistleblower, obviously there are whistleblower laws that would provide protection of those records outside of the Public Records Act. It's not saying that they're not public, they're just not disclosable because another law protects them. So, okay, we've got the whistleblower complaints, we got maybe the sexual harassment complaints, those kinds of things that are protected from possibly various different laws. But here, we haven't heard about any particular one. So when I asked about, are there any responsive records, the answer was no, but, and the rest of the statement. So that's kind of, I'm kind of left with that. Kind of a dangling participle here.
To be clear, so if we look at the top of page 1476, Mr. Vu does cite different exemptions under the California Public Records Act and under San Francisco Administrative Code. And are we saying that you can't just throw all of these out here? They have to be tied to the specific requests? Is that what we're asking for?
Well, we're asking, when they say they don't have any records that are responsive that are public, and they're withholding other documents that they feel are not public, that's why they're here.
Right.
For us to determine whether they are or not public. Okay, this is the first step in the process. The next step in the process is you go to court to try and get a court order to disclose them. The only enforcement power that we have, even in this section, we do have some, and that is to compel. And if there is a defiance on that to compel, then we can send it over for enforcement to any number of departments, other law enforcement departments, whether it's the AG, the DA, or the Ethics Commission, or a petitioner can take it to a court. And the court's first thing the court's going to say, oh, San Francisco, they have a local process, don't they? Did you exercise that? Well, yes. And here's what happened. And then, that provides some additional breadth to that case. So, I'm sorry, where was you? It's on 1476?
1476 at the top.
It's starting with assisting in the defense?
Yeah,
of?
I mean, if you look at the sentence begins on the page
Oh,
above.
okay, for items 316, okay. Okay, so there you go. Good find. Do you want to ask a question?
Well, actually, I guess are we then asking for an index of what exists and why it is either exempt or being withheld?
So then their statement is, therefore, those records are not public records subject to disclosure, okay? They're here. We're here to determine whether they are or not, okay? So how do you wish to proceed on that? And is there a violation with regards to now withholding because they determined that they're not public records? Well, we haven't seen them, or we don't even have a list of or catalog of them to determine those that they are withholding because they cite that they're not public. That's for us to determine. Now, we have made determinations and found in favor of respondents for a lot less than what is available to us in camera, because we are not a body that has that ability to see things in camera. It would have to be offered. So sometimes we get hamstrung. Yeah, Member Yankee.
I was going to say, I was looking through the Coronado case, and part of what concerns me here is that it seems to rely in part, not entirely, on 6255 of the Public Records Act, which is kind of that, with their like the catch-all provision, the balancing test, which may be very applicable under the CPRA, but that makes me question about, well, do the enhanced provisions of our Sunshine Ordinance perhaps make that not applicable here in San Francisco?
Well, CPRA flows through the Sunshine Ordinance. It's like, and we have been given authority by the voters to actually find violations of both the California Public Records Act and the Brown Act and the Sunshine Ordinance, because there are items in the Sunshine Ordinance that...
Right, and that's my point. I mean, that's what I'm saying. So while Coronado might exist and say, okay, under just the CPRA, it might be,
That's right.
Okay, but we, I think, have to apply even greater scrutiny, and I'm not
Well,
sure.
the question is are the provisions that we're discussing here already contained in the CPRA? Okay, and I believe that to be the case. They would have to confer with legal counsel to determine if 6721 is kind of a reference of the CPRA, or whether it is unique and specific to our Sunshine Ordinance, and then what of the other provisions that are being cited by the petitioner as violations, like the justification for withholding, 6727.
Right. So I think
in the microphone, if we don't mind, get it on the record here. DCA Peterson.
I think the short answer is that the Sunshine Ordinance does largely incorporate the CPRA, but goes beyond it in some important respects. And with respect to Member Yankee's comment about Coronado, I just wanted to say the court applied the catch-all exception clearly, I believe, in the alternative to its determination that the records were not public records.
Can you expand on what you mean by that?
Sure. So as I read Coronado, the court said, these are not public records because they are not the public's business. They're pursuant to a private function of the public defender's office. And then it went on to say, but even if they were public records, the catch-all exception might apply.
Okay. What about for the purpose of that because the California Public Records Act is different than other laws in the state, most other laws in the state, which allows for this enhancement for additional transparency and expediency that is applicable under law in the locality of where it exists and the request is being made. How does Coronado then apply with regards to that? It doesn't, it's really more that the Sunshine Ordinance, in the way it's been explained to me, actually has that authority to ask for that extra stuff. That's what we do here in San Francisco. That may not apply in, some other city.
No, and I think that's right. I think that the CPR sets a floor that a locality could go beyond. But I don't know that the logic of Coronado is necessarily undercut by the Sunshine Ordinance.
Okay. One of the things, there's a passage in another case law that we're going to hear later. It's the Attorney General versus the Superior Court of the City and County of San Francisco and the First Amendment Coalition with regards to the release of misconduct information of law enforcement officers. And it's in their opinion, in the court's opinion, this is the Court of Appeal of the First District, Division 3 in California. It also talks about the catch-all exception. And I don't know whether this is helpful or not, but I think it's worth reading. It states, we conclude as a matter of statutory interpretation that section 832.7 generally, and 832.7 is the penal code, generally requires disclosure of all responsive records in the possession of the department, regardless whether the records pertain to officers employed by the department or by another public agency, and regardless whether the department or another public agency created the records. Also, although we also determine as a matter of statutory interpretation that the so-called, quote, catch-all exemption, unquote, of the CPRA, codified in Government Code Section 6255, may apply to records that are subject to disclosure under the Penal Code Section 832.7. Our independent review leads us to conclude the department did not adequately demonstrate that the public's interest served by non-disclosure of the records at issue clearly outweighs the public interest in their disclosure. The petition and their petition for writ, this is the Attorney General's petition for writ of mandate is denied. So it's not quite exact, but it does interestingly touch on Coronado with regards to the catch-all exemption and whether information that is being held by a public agency, whether it is about that agency or about another agency, is disclosable. Is that correct? I
think that's a fair summary, although I'll just say a couple of things about that.
We don't take any.
I know it's not a question or answer. I am leaving, and I just didn't want to show any disrespect. I'm about to miss a flight, and I think you're done with me. So,
no
is that correct?
That's fine. You'll
Okay.
find out we'll notify you what the result is.
Okay. Thank you very much.
Mm-hmm.
I think that's a fair summary of the case, which generally holds that if the public entity has the records, it doesn't really matter how they got them or whether or not they created them itself. I think the catch-all exemption discussion in that case is kind of sui generis in the sense that, it's kind of fact-specific. They're saying, in this case, the catch-all exception may apply, but you didn't make out the case that the public interest, in non-disclosure outweighs the public interest in disclosure.
Okay. All right. I'm going to stop here and ask for a motion. I wanted to just allude to some of that stuff because it was, I think, based upon that it's in front of us, that it applies. And So. So I'll offer this. You can kind of maybe split it up a little bit. If you wanted to find a violation for one thing, and then on another thing, you wanted to make that continuous, you can send it to compliance and amendments to continue following up on that particular item. Let the committee, which has more time to go through things, because we're already beyond an hour for this one. I want to kind of, because we have one more case, and I want to make this another lengthy meeting that it already is. So if you want to do something like that, we can do that. And then if you're unsure about other parts, like for instance, I'm unsure about the records that were assembled that were not considered public records. I like for the task force to make that determination whether they are public records or not, or provide some citation of law that states that those particular records are not public records. And again, they may be public records and protected in some other way. The question is there citing here that they are not public records, that they are for a private function relating to the conduct of the public's business? And the question is then what is the private function? Wait, like what's the private function of the public defender's office? That would be a good question. I'll ask that question. Mr. Vu, what is the private function of the public defender's office?
Represent the person.
Please,
with great pride, I would say that we represent poor people who are charged with a crime as though they have money.
But who decides that it's a private function? Where does it say that the public defender's work is a private function?
I'm sorry, if I may consult with someone more senior.
But just the Supreme Court now just made it clear that we serve as individual attorneys on each case, attorney-client. It doesn't matter that we're employed by the state, we can't share it with each other. We're attorney-clients as to that.
I think I should have said this, I should know this, but it's the Supreme Court that basically said that when you have a public defender as your attorney, that attorney is loyal to you, an individual privately, that attorney has a duty of attorney-client confidentiality to you privately as an individual. It does not matter that the person that foots the bill for it is the public. So I guess it's so foundational.
Okay, and so we are mostly lay people here. Okay, we are not attorneys, even though we rely on our legal counsel. That was not a citation in your defense that you included to prove that with regards to the private function part that you're also citing for Coronado. Now, it may be common knowledge for attorneys, but it may not be common knowledge for the rest of the public. And so that I contend is what is at question here with regards to then determining the collection of records that you have, if you're saying that they're not public because they are part and parcel of the private function of the public defender's office. My question, my kind of statement or my challenge is prove it. I mean, we need to see that Supreme Court ruling to be able to show that the public defender is, in fact, providing a private function to the general public. And so then we can go from there, because that's the crux of your argument in your defense.
Well, I think that I can cite to specific case law in Coronado where the court essentially says those exact things that you would like me to prove.
Okay.
If I may.
Okay, that's fine. Sure. Let's do that. If that will help everybody here, Would that create some confusion?
Actually, I think this is, at this point, listen, the person's been charged with a crime. They have a right to a defense and a right to an attorney and a right against self-incrimination. I mean, the Supreme Court has a litany of cases that says those attorney-client working relationship doesn't, it's the client holds the privilege of whether all that documentation gets released or not.
Right.
So, to talk about that more, I think is maybe not the most efficient use of not a lot of time left.
Well, I understand. I just my point here is there and I'm basically just picking up where the petitioner had stated that they stated here that, and Member LaHood found it, that items 3 through 16 were assembled and retained for the purpose of assisting in the defense of existing future clients.
Well, right, and
as a quote private function relating to the conduct of the public's business. Okay, so then they say, then they're concluding based upon that, therefore the records, those records are not public records. But which records?
Well, right, and I think that's the crux, obviously.
Well, that's what I'm saying is we get to determine which records. That's our job, is to determine which records are public or not.
Right.
Okay, it's either us or it's the supervisor of records, who is the city attorney.
Correct. But at the same time, I mean, I think my general feeling is, listen, there's records out there. I don't think they're asking for attorney-client stuff. They're trying to roll it into that.
That's my point.
Right.
We need to know what those records are, at least a catalog of those records, so we, with citations like this one's private function,
right.
This one isn't private
function. And I think
function.
we're there already at that decision point.
Okay.
You know what I mean?
I would say then make a motion.
Okay, then I'll make a motion.
Because I'm not sure that I am.
Okay.
Okay.
All right.
I'm sorry. Mr. Vu, did you want to?
Yeah. Sorry. If you have.
Did you have you want to finish your statement regarding the private function part?
Sure. So just regards to the database that the court was mentioning in Coronado. And what the court said in Coronado was that, quote, the database is not a public record because, quote, the core function of the public defender's office, which is the representation of indigent criminal defendants, is, and I quote, and I emphasize, a private function.
But wait a minute. So we were talking about a database, okay?
But
in Coronado, what was the information in the database?
Public information gathered about police officers in the course of, or the database contained both public information that was gathered in the course of collecting news tidbits, as well as in the course of representing clients individually. So the Coronado database had everything. It had public and it had private stuff. It meshed it together. And what the court said was that the court said that the core function of the public defender's office is the representation of indigent criminal defendants, which is a private function.
Police misconduct. Remember that misconduct.
Concerning both items in the database concern police misconduct, the court concludes on page 107 of that. 1007 of that opinion that the public defender is not acting as a state agent when representing clients.
Member LaHood?
Okay, I want to state, so it sounds like what you're saying, even though there was public information in this database, and there was other information that was gathered that may have been publicly available that was put into this database, the database was compiled for the purpose of defending clients. And because it was created for that purpose, even though it contained public data and other readily available data, making this easily accessible database available to others to use did not serve the interests of the clients for whom it was created.
It did serve the interests for the
clients.
Right,
it served the interests of the clients, but giving it to the other side did not serve the interests of the clients.
Giving it to the
opposition
did not serve, of course not.
Right.
Did not.
So, and okay.
Okay. All right. Thank you, Mr. Vu. Is there a motion? We have motion on time. There's a point on timeliness, and there's a point on responsive records. And the responsive records has been the bulk of our conversation here, pretty much.
I was going to say, I forget the timeliness portion.
The timeliness was that it was the period of time between the request and the receipt of the first record. And I think that was beyond
The timeliness appears to be quite significant because there's two 14-day extensions in addition to the 10 days. That's the easy one from where I sit. Everything else is kind of murky.
So as I said, if you feel that the other parts of the complaint are still inconclusive for you, you can make the choice to continue those items. You can refer it to committee for further investigation, and have it returned back. It's up to you. It's up to you guys. I'm neither here nor there on it. Yeah.
I'll go ahead and make a motion for a violation of timeliness and leave open the other issues referred to, I guess, which committee is up to the call of the chair. So that's my motion.
Let's do it for complaints and amendments.
That's what I would have recommended.
Okay, so timeliness under 6721, what, B?
Yeah, B.
Okay. All right, is there a second to the motion?
I'll second.
Rest of that motion, so you're finding a violation of 67.21B for timeliness, and you're requesting that the remainder be referred.
So the remainder would be to the determination of whether the existing records that have been withheld, that the public defender's office is deeming as not public, for them to bring information to show that they are in fact not public. And if they are part of the private function, they need to kind of show that. I'm sure in the Coronado case, I haven't read through the bulk of it or read the transcripts from it, that there was all kinds of discussion and possibly in-camera look for what the information is, so that a proper determination from the appellate court could be made, or that was information that was brought forward from the lower court. I don't know. I didn't dive that deeply into Coronado, but that's what we're doing here is. So it'll be for this. So you can refer to page the bottom of 1475 and 1476 with regards to all records responsive to items 3 through 16 were assembled and retained for the purpose of assisting in defense and existing of future clients. A private function relating to the conduct of the public's business by the public defender as ordered by this case law, the Coronado case. And then they go on to say that the records are not public records subject to disclosure. The task force is not fully convinced of that, and they would like the public defender's office to provide further proof that those records that were assembled are in fact for the private function, and that how they are not public records subject to disclosure. Now you can recite Coronado, but I think it needs to be a little more detailed, and I think it's best that it be heard a little more time and a little more effort at the Compliance and Amendments Committee, and they may come back with exactly, they may come back with in support of the respondent. I don't know, but I think it's worth a look-see. I think everybody is wanting that.
Can I ask a question through the chair, I guess maybe to our city attorney on this? I understand that there are obviously going to be situations involving attorney-client privilege. Is that the same thing as private function, or are there two separate categories? And is there some slice of what we're talking about that is not protected by attorney-client privilege that's under private function that's still a public document or not? Like, are we talking about 2 circles or 3 circles?
I think the way I read Coronado is that if materials being assembled in the context of representing individual clients, then that's a private function. And as counsel pointed out, in that case, there was a database that included both private information and public information. Public information gathered from court filings and news reports, which clearly could not be subject to attorney-client privilege. So the question before the court was, is this a public record? And the determination was, it's a private function because it's gathered solely for the purpose of representing these individual defendants. I'm not sure if that answers your question, but there are two. I think there are 2 circles. There's the Coronado circle, and there's attorney-client, attorney-work product circle, which are not necessarily coextensive, although they do overlap, except for the fact that the database at issue in Coronado was almost certainly work product, even though it contained certain public information because it was gathered for the purpose of representation.
And you could also say the way the public information is situated in the case could reveal the strategy of how a case is being presented. Okay, the thing is I think for determining how that all works. What's important here, I think what's important is how we determine things here creates when it's in this kind of in a global nature. If we make a decision based upon this could have wide-ranging effects on other cases. Like the respondent was saying, if we were to find that the information was public, it could have a drastic effect on the work that they do. Okay, so I think it's important. Like we've been dealing with a lot of other very interesting issues regarding like the metadata issue. Okay, things like that. I think we need to be able to be very careful in how we make these decisions and create good precedent and good position that is sound. And where it feels gray and possibly vague to us or not understandable, that the case needs to be made even more concrete, so that way when the next case comes that asks for the same thing, that this task force, no matter who sits on it, has a good historical record that it can fall back on, and they don't have to kind of reinvent the wheel every time. And then for whatever the reason, if they find in favor of the respondent, they can feel comfortable to continue doing the business they do. Or if they don't find in favor of the respondent, then they're going to have to figure out how to deal with that next, okay? And whether what happens here has any bearing on that at that point too. So I think it's best that let the conversation continue. We'll see what happens at the Compliance and Amendments Committee. It is open and observable to others that are not on the committee from the task force. If you want to sit in and watch it, there's not I don't think there's a quorum issue with regards to that, as long as you're not sitting on the dais. Okay.
Is there a second?
It was moved by
Vice Chair Wolf.
Vice Chair Wolf.
I second.
Member Martin seconded it. Okay, public comment. Okay, let's have the person on the phone first. Go ahead.
All right, Anonymous here. So I think it's definitely a good idea to have much more discussion and analysis on this. The chair is exactly right. This will essentially be a huge precedent, even bigger than metadata, because the question is not about burden. The question is this information fundamentally public or private? And I think the conversation between Member LaHood and the DCA was to me, the crux of this case, that different requests, they have cited this kind of blanket across all the requests. But between 3 through 16, I think it's that 5, 6, 7, 8, and 9 are not really anything to do with how they are preparing their own cases and finding allegations against the district attorneys. But the allegations against they themselves, in my opinion, should be public records. That's somebody else filing an allegation against them. But what they are researching, even when it's against the district attorneys, I think is not even a public record under Coronado. It's not the question of whether it's exempt or disclosable. It's just not a public record. And I think that's because the Coronado case specifically says, quote, to perform its work, the public defender must be allowed to assemble information so that it can sift through available facts in order to prepare legal theories and plan strategy. To carry out this work, it must be free from unnecessary intrusion. And I think that is why they're preparing this other information. Even if it's not in a specific case, it helps them help their clients. Thank you.
Yes, hi, I'm Thomas Osley. I was the original petitioner. I worked at the DA's office for 6 years, and I'd like to make a few comments.
Pull the mic up.
Is this better? So first of all, the idea that these allegations of misconduct are not documented is absolutely false. Each of the persons named in that petition, when they committed misconduct, or I believe that they committed misconduct, I reported it to my supervisors via email. Allegations against me were made via email. The emails I exchanged with public defenders accusing me of misconduct, I forwarded to my supervisors. The Public Defender's Office filed a bar complaint against me in June of last year, June 24th. In that complaint, they made multiple allegations of misconduct, and they tried to do it under seal. I moved to unseal it, saying that I'm a public official. Allegations against me should be transparent and should be public. And I thought it was reprehensible that they would try to hide allegations that were being made. Moreover, and one of the things that I find most frustrating is that the public defender tried to subpoena both my work and personal phone in a criminal case. They actually filed a criminal subpoena in 2 separate cases trying to get my personal phone records. It didn't work, it was quashed, but the proper form to have done that, the proper form to have gotten my text messages and my emails would have been here. So to come and say that those records are not public when they themselves had tried to get them through an improper avenue is frustrating, to say the least. But this whole thing about Coronado does not apply to what I'm asking for. A public defender saying, and this is, I've listened to it in jail calls, and I believe it was Mr. Martin pointed out that it's the client who holds the privilege. If an attorney goes and speaks to their client, and that client decides to publicly say what the conversation was, it is no longer attorney-client. I have listened to jail calls where some of those public defenders said that I was a corrupt DA and they were going to get me disbarred. Now that is no longer attorney-client. You cannot go as a city employee and decide that you're going to ruin somebody else's reputation and career because of personal problems or personal vendettas. I am not the first person that this happened to. I was the ninth person that they've done this to. Alona Solomon, she is behind 5 of the bar complaints that were filed, and she's proud of it. She says so in the moving papers. And when I say moving papers, a lot of what I'm talking about has already been filed in criminal court. This is all, there's no attorney-client, none of this stuff is private. If anything is, they can identify what it is. But if they're sending an email to my boss saying I should be fired, they should turn that over and they should stand behind what they say. But Coronado does not apply to anything that's being requested. Thank you.
Okay, is there any other public comment on the motion? Seeing none, please call roll.
On that motion, Vice Chair Wolf.
Aye.
Wolf, aye. Member Martin.
Aye.
Martin, aye. Member Yankee.
Aye.
Yankee, aye. Member Highland.
Aye.
Highland, aye. Hinsey, absent. Member LaHood.
Aye.
LaHood, aye. Tesfa, absent. Chair Wolf.
Aye.
Wolf, aye. The motion passes. The matter will be referred to the Compliance Amendments Committee after the violation.
Thank you. Okay, we have
One more.
Sorry?
One more.
One more, yeah.
Next on the agenda is item number 11, file number 19123, complaint filed by Paul Quinta against the San Francisco Municipal Executive Association for allegedly violating Administrative Code, Section 67.21, by failing to respond to a public works request in a timely and or complete manner.
Okay. Just want to thank for the previous folks. Thanks the parties for attending and your patience with the process. I do, but it's 9 o'clock, and I really need Petter, if you can stay to talk about that case law, I really would appreciate it. Okay.
Oh shit, there's 6 of us again.
I'm gonna break quorum if I go. Can as long as I'm not voting, is that okay? Okay.
All right, so I'm sending, my service dog needs to go out really badly. I'm sending out one of our members to.
We don't have quorum without.
But we're not taking a vote, so.
Okay.
We can start with the opening statements, and then when we get to deliberations. Okay.
And I need to leave at 9:30.
Okay, well, hope we can get through this fairly quickly. All right, well, we stay in a recess till his return. It'll be about five minutes. Did you miss it?
Got delayed. He missed his flight.
Oh, I don't plan on our meetings going this long.
Oh, yeah. If you don't know where you're going and then big spot.
Well, hopefully you don't get 2 a.m. airport runners.
Case was,
We had 3 cases that we didn't discuss. I know.
yeah, I'm sure
That was like the closer.
You know, there's no way to get ready to leave the office. It's just so much.
You just, I know. You just can't even look at the email when you're out. It'll give you anxiety and stress you out.
Again, you know, it's like 2 weeks out. These people that are, as opposed to all these people are, you know, ones that eat out 40 hours. But anyhow, otherwise you would have voted for these things. It's one of those things where.
Delaying to do all of it
yeah.
at once, I think.
Yeah. Right.
the problem is that questions.
Oh, because he's not a member. I was like, wait a minute. I kept looking, I was like, he's not a member. I kept looking, I was like, he's not a member. I was like, how the hell did he show up?
But I mean, that's, and he just said they're.
You left the thing running.
Well, they recessed when you were sitting. Pause it now.
Okay, we're back on the record. The meeting's commenced again. We have quorum. Please read file 11.
Item number 11, file number 19123, complaint filed by Paul Kingha against the San Francisco Municipal Executives Association for allegedly violating Administrative Code, Section 6721, by failing to respond to a public records request in a timely and or complete manner.
Okay. This was heard by...
This is the one we
compliance.
heard last week.
Yeah.
Yeah.
Do you want to give a
Sure.
quick...
This is actually very interesting. Our petitioner was seeking information that he believed was public, but we determined that we did not have jurisdiction because it involved documents or information held by a union representing city employees, but not a public body.
Right. And I believe the petitioner was here, but it now is not here. So we're going to, I think we should just move ahead with the case. We'll go as far as we can. I've already spoken to at least one of the parties that said that if we had to continue it, as long as they're the first ones on the next meeting, which I assured them they would be, to do that. But I'm not sure that it will take that long with regards to this. Well, the petitioner isn't here, so why don't I call all the other parties? We'll see if he comes back. We'll take it from there. Okay. The petitioner was here just before we had to take a quick recess. All right. But we're gonna forge ahead on this. If anybody has any objection to that, please say so now.
We're going to hear it in reverse order, is what you're suggesting?
We'll hear from the we're going to hear from the. I'm going to call for witnesses and persons on behalf of the petitioner, then ask for the respondent, ask for witnesses for the respondent, and then we'll see if the petitioner comes back. This first part, it doesn't really matter. What's really more important is the rebuttal part, that the petitioner has the last say.
Yeah.
The first part is just the presentation. So we're just going to hear the opposing party's presentation at this point. There's lots of information with regards to the committees. We had full-on discussion about this. So you can read, if you read through the minutes of the Compliance and Amendments Committee that heard the complaint, a lot of the substance is there. Okay. So are there any persons or witnesses providing any facts or evidence on behalf of the petitioner or the complainant? Okay, seeing none, the respondent. You have 5 minutes.
Good evening. I'm Chris Romero. I'm a union rep over at Municipal Executive Association. And I really appreciate the determination this body took. We are not a city agency. We're a labor union and have been so for decades. I did see the letters that were sent by the Department of Human Resources alluding to what's called direct dealing when, we have bargaining. The labor representative is the sole negotiator for the employee. And in this instance, the employee in question is Mr. Niha. He is a member of a part of our bargaining unit, but he's not a dues-paying member. And so it's very unusual that we have this type of situation. But I can assure you this is not the body where anything between our union and Mr. Niha would be adjudicated. So I'm not sure what else I can say aside from the fact that we're not a city department and HR has determined that, and so has the city attorney. So I don't know if you have any questions.
We take that after you're done with
Okay,
this
I'm
opening
done.
statement. Okay, great. Are there any?
Your name was Chris Romero?
CRISSROMERO, and I will give you a business card.
Are there any persons or witnesses providing any facts or evidence on behalf of the respondent? SFMEA. Nope. Okay, great. Members? Questions?
I mean, we had a good discussion about this in our committee hearing. And, you know, it seemed pretty clear that we don't have jurisdiction in this case. So I don't know if you want to elucidate.
So the question here, since the recommendation from the finding from the committee level was that was no jurisdiction. If we find, if the task force should determine whether there is jurisdiction to overturn the committee's decision or recommendation. So that would be the first thing. If you continue to hold that the committee is correct in their recommendation and and is recommending that the task force continue to find no jurisdiction, then we'll move things along fairly quickly. Go ahead.
So the complainant was here tonight and then left.
Yeah.
The complainant may or may not have an argument as to why this isn't as it was perceived by the subcommittee. Our standard process when the complainant is not here the first time is to continue the matter. In this particular case, I think that we can log what the representative from the MEA had to say, and they don't need to come back if they don't want to. I think they've met the obligation they conceivably don't have. But I don't feel comfortable addressing whether or not we have jurisdiction without the person who could make the claim that we do have jurisdiction not present.
Anybody else? Member.
Could we ask the DCA to weigh in on this? I mean, I think that determination comes before we hear anything. I mean, you know, even in subcommittees, we look at that piece first before we get to the merits of anything, and that's kind of where we're at based on how I'm reading this. So, is it clear cut that labor unions don't fall? There's no exceptions that, you know, even though they're advising or working for the government, you know, once, twice, thrice removed, whatever it is, they don't fall under our jurisdiction.
Yeah, I believe that's true. They have a legal need to keep separate from the city departments that they represent, apart from in collective bargaining. And so I think that that's pretty clear cut.
Pretty robust.
Yeah.
Okay, thank you.
That's what it seemed to me, although I don't oppose Vice Chair Wolf's request that we handle this in front of the complainant.
So is there...
I'll make a motion to continue this item, excuse the respondent from being expected to attend, to allow the complainant the opportunity to be heard on whether or not there actually is a jurisdictional basis to move forward.
Okay, great. And what that means for the respondent is if at that time the task force has been convinced that there is a jurisdictional issue and it reverses the committee's finding, then we'll re-agendize this, reschedule this for a full hearing to hear all the merits and take it from there.
Was there a second on the motion?
I'll second.
So moved by member Vice Chair Wolf, second by member Martin. Is there any public comment? This is on jurisdiction. This is on continuance only. Seeing none, are we ready for a vote? Okay, please call the roll.
Vice Chair Wolf?
Aye.
Vice Chair Wolf, aye. Member Martin?
Aye.
Member Martin, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Tesfaye, absent. Member LaHood?
Aye.
Member LaHood, aye. Member Hensy, absent. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. And the motion passes.
Okay, great. All right, let's call the next item real quick. I just have one thing to, go ahead, call it, please.
Item number 12, reports from Sunshine Ordinance Task Force Committees. I included the January 28th Compliance and Amendments Committee minutes.
Okay, so the compliance, with the Compliance and Amendments Committee minutes, you still have Frank Canada as chair in there, so that needs to be changed.
Yeah.
And Chris Hyland's name is on there too, but Member LaHood and myself are in the context, so just a typo there. Okay. And so what we're going to do is we're going to approve these minutes? No.
No.
They were
it's
just
got-
presented?
Presented,
Right.
yeah.
Okay, great. Okay, is there anything from committees that are, anything you need to bring up? If not, let's move. Any public comment on committees?
Yes.
Go ahead.
Yeah. So I do hope at some point that I think it's your amendment committee may want to take a look at some of the it's the rules committee to take a look at some of the amendments to your procedure that I've suggested. That's all. Thank you very much.
You're welcome. It's received and will go out to the task force members for review too. Okay, let's move on to the next item. There's no more other public comment.
Item number 13, Sunshine Ordinance Task Force Chair's Report.
Okay, so the first thing I just want to say is I sent out a notice that I'll be attending they call Government Q&A. It's a group that goes around the country holding court for around public disclosure and public meetings. It's going to be February 11th. And there are going to be 3 or 4 departments from the city here, including, I think, the city attorney's office is going to be there too, I think. But if there are any questions, I put it out with all the information. Take a look at the email. The second item is you may have you received a couple of pieces of case law that I wanted, I've asked Petter to, and Mark, our DCA's legal counsel, to fish out if there are any case law that it pertains to how we make decisions. Like the one that he found for tonight actually was pertinent to the case around the Coronado stuff. So I think it's important that when there is case law in California and elsewhere, and I sent out some other stuff also around the country that might allude to some of our insights to help us make decisions. So the first case was this, the California Attorney General versus the Superior Court of City and County of San Francisco and the First Amendment Coalition. This is around that the receiving of what has been held as misconduct records on the police, on law enforcement, and the Attorney General has been trying to protect that. This particular case that is a writ of mandate that was brought before the Court of Appeal that we discussed a little bit earlier. I'm just going to leave it to Petter to say a few words about it. You just highlight what might pertain to what we might have to consider. That would be good.
Sure, I think we covered this one. You covered it pretty well earlier. The basic holding is, that the Department of Corrections was contending that under these new disclosure requirements for police misconduct, it had no obligation to produce records that it didn't pertain to its own employees or that it didn't create. And the Court of Appeal rejected that argument in the decision that came out just last week, saying basically, if you've got the records and they're disclosable, you have to disclose them. I don't know what the status of that one is going forward, whether or not there's an appeal. It's too soon to know. But there may be, a request for a review in the Supreme Court.
Okay. Any questions regarding that? Okay, I would read it through. It's pretty interesting, but I think it was pretty key to kind of the issues that we were dealing with in that previous case.
Is that the Javier Becerra one, or?
No, it's the Xavier Becerra versus Superior Court.
That one, yeah.
That one. The next one is San Francisco Urban Forest Coalition versus City and County of San Francisco. And this one is in relation to what is or what is not a local agency when it comes to a county or regional type of body. And in the ordinance, there are references to such in 6732 being it's including but not limited to Presidio Trust, the Unified School District, Community College District, the Transportation Authority, the Housing Authority, Treasure Island, is all, goes on and on, University of California, that they, even though they operate in the confines of San Francisco, they are not obliged to follow the Sunshine Ordinance because they are state bodies. They are not local bodies. And so
the school district?
School district
Wow.
is a state body. It's under the California. Yeah, these are districts of the state. And so they live independently. But they operate here. And so that was partial also. When I was going to City College, we always would, kind of scream the Brown Act to the Board of Trustees, but we'd say sunshine, sunshine. They're like, we don't have to follow it. And so it was a big deal over that. So anyway, this particular case talks about the, which one is it? It's called the Bay Area not Bay Area Transportation Act. It was, what's the name of the body? The body was
San Francisco County Transportation
County
Authority.
Transportation Authority.
SFCTA.
Okay, and basically this is very interesting because it talks specifically about what is a local agency, whether this is a local agency or not. So, Pedro, why don't you pick it up from there?
Sure. So this is a very complicated case in terms of the factual development. There was a state statute passed that enabled localities to create certain transportation bodies in the Bay Area. By initiative, San Francisco voters established this transportation authority. And the court went on to evaluate whether or not it's subject to the Sunshine Ordinance. And it basically said just because it's a local agency does not mean that it's an agency of the city. And the fact that it operates only within the geographical confines of San Francisco doesn't make it a city agency, and that the main crux of the decision was that the legislative intent of the statute that enabled this body to be created was to establish separate entities, and therefore it's not subject to the Sunshine Ordinance.
Even though it was created by local voters.
Correct. And that's what's interesting. I think
Right.
the most interesting thing about it is that it was by initiative by local voters, and there's currently a petition for review pending with the California Supreme Court.
So I have a quick question. Because we are a city and a county, how do we separate ourselves? Where is the bright line?
Well, I don't think that there is a bright line in that regard. I think that what the court was doing is looking at, I don't think it was drawing the distinction between city and county. I think what it was doing is saying the enabling statute was intended to allow the establishment of these transportation authorities in the Bay Area counties, and that they were not intended to be part of the local government.
Like a water district?
Perhaps.
Or a joint powers authority?
Yeah, something like that. Although, I mean, the interesting thing here is it was by initiative. It only operates in San Francisco. Other counties in the Bay Area may or may not have established similar bodies.
Okay.
But I haven't seen case law on that.
Okay, so this one is really very interesting because it specifically cites the Sunshine Ordinance. And the question I have then is was the ordinance passed by the city or is it passed by the county? And how do you fit those two together? Because the court continues to cite that it's the city's Sunshine Ordinance, but we're talking about a county transportation authority.
But isn't this a regional transportation authority? Isn't this pertaining to a small section within this regional decision? It's not the county so much as a subsection of the region.
Well, that's that's what I'm asking everybody to kind of take a look at. See if you have any questions, and if you think that there may be a challenge to it, then let's have that discussion.
Right, but whether it's county or something else, I think is important, because as far as in going with what you're saying, that I haven't ever heard a distinction between the city and the county as being the issue. Like, our education system isn't because it's run by the county of San Francisco.
Read the case. They make some very interesting summations in there. I would read it. It's not as black and white as that.
Quick question. The Sunshine Ordinance was that created originally at at a state statute level and then voted on us, or was it strictly
The Sunshine Ordinance?
Prop G?
No, it's Prop G.
And
The CPRA came first, and the Brown Act came first, and then it provided the added enhancement for local agencies to do. So please read through all that, and if you have any questions, you can forward them through Cheryl if you have questions for DCA Pedersen or not. So we're losing quorum, and we're going to have to adjourn by a standing vote.
Right. Can we still hear public comment on that item?
We really just have to end the meeting. We can't discuss anything once we lose quorum. That's kind of the rule, unfortunately. So whoever was still around, apologize for that. Meeting is officially adjourned.
Thank you. Good night.
Good night.
What you're doing there for a second.